Good evening, everyone. I'd like to welcome you to the Zoning and Planning Board meeting. I'd like to ask everyone to rise and salute the flag with us.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. May we have roll call, please?
Chairperson Cleveland.
Here.
Vice Chair Dickinson.
Here.
Bushian. Here. Kachowski.
Here.
Fullerton is absent.
Excuse Stephen Whitney's out of state on vacation.
Alperley.
Here.
Gunn.
Here.
Calvadas.
Here.
Kapadas.
Here.
Beatrice is absent. And Robert. Solicitor Ryan.
Here.
And John Pettit, engineer.
Here.
Keith White.
Here.
Okay, thank you. Public notice of this meeting pursuant to the Open Public Meeting Act has been given by the clerk in the following manner: posted on the bulletin board in the Borough Clerk's office, emailed to the retrospect, and the Courier Post. At this time, I entertain a motion to approve the minutes of the October 9th meeting.
So moved, Madam Chair.
Second.
Okay, motion made by Mr. Dickinson, seconded by Madam Mayor. All in favor?
Aye.
All right, the first matter we'd like to address under new business this evening. If anyone was here last month, we had discussion on allowing drive-through windows in Borough. We had a long discussion, and it was the majority of the members up here thought that it would be a good idea. So basically what we're doing, it's going to be a conditional use, which means they have to come before us before they put a drive-through in or cut a hole in the side of their building. It's not going to be a free-for-all where, you know, every pizzeria and donut shop can just do what they want. It's a conditional use. Anyone that wants to do this has to come before us with a site plan, and they have to present it to us, and engineering and the solicitor will examine it and make any necessary changes that they believe would be needed to make it a good plan, okay? So we asked our solicitor, Mr. Rowan, to prepare a resolution recommending to mayor and council of the Borough of Runnemede by the Planning and Zoning Board of the Borough of Runnemede to amend the land use ordinance of the Borough of Runnemede in order to allow drive-through windows as a conditional use within the commercial zoning district. Mr. Rowan, do you want to read the resolution?
Well, I think what you just read, it is just a recommendation to mayor and council of,
Yep.
to examine that. I mean,
Yep.
so the public isn't confused. We're not making that a
Recommendation.
rule or regulation. It's just our recommendation when our land use ordinance is updated, that they consider adding permission to have drive-through windows in, as a conditional use within our commercial district.
Is there anyone in the public that wishes to speak on this matter, have any questions on this? Again, it's just a recommendation. We're not acting on it tonight. We're recommending this to mayor and council, and they will act on it as they see fit. If anyone has a question on it, we're certainly here to talk to you.
Seeing no one.
Okay, second? Okay. Motion been made and seconded to close the public portion of the meeting regarding the new business resolution for drive-through windows. Hey, Mr. Rowland, should we do a roll call? I want to do a roll call. I want to do
approve the recommendation.
Yeah, I want to
and
do-
then take a roll call.
So, need a motion to send a recommendation up to mayor and council for approval.
Second.
Discussion, and Mr. Opperly. Have a roll call, Jim?
Playhammer.
Yes.
Dickinson.
Yes, for conditional.
Bushian.
Yes.
Kachowski.
Yes.
Fullerton is absent. Alperley.
Yes.
Gunn.
Yes.
Calvadas.
Yes.
Kapadas.
Yes. Okay. Being that accepted. Next matter of business is the application for preliminary and final site plan approval for the DPE 160 Runnemede Associates, which is the Rich Group. You guys like to come on up and do your presentation?
Thank you, Madam Chair,
You're welcome.
members of the planning board. I'm Joseph Nardi of the law firm of Brown & Connery on behalf of the applicant DPE 160 Runnemede Associates LLC. Also present is my client's engineer, Gary Cavalier, who will be able to walk us through some of the changes to the existing site where construction already exists and has since the late 1990s. I'd also introduce, and I know members of the board are familiar with, David and Philip Richards, who are principals in the applicant. Frankly, what we're doing here, as I've indicated, it's a building that's existed since the late 90s, and there's prospect for adding some additional tenants. There is one tenant in the building at this time, and there is an opportunity in the future, and discussions are ongoing with the improving economy, so the possibility exists that there will be more employees coming to the borough of Runnemede. What we need is additional parking. Presently, we have 112 parking spaces. We're looking to add 76. We're not asking for any variances. We're looking to, because of the parking requirements, or what we'd like to ask for, the parking request, we have to add 2 small retaining walls. There have been some suggestions made by Mr. Pettit in his letter of November 15, 2013, which has been reviewed by my client as well as by our engineer, and the discussions have been undertaken with Mr. Pettit as to what might be necessary. We're prepared to walk through that. We're going to relocate a few trees and some other minor items, but other than that, I think that we are prepared to basically a very straightforward application to add additional parking spaces. I would like to do, if I could, Madam Chair, I have delivered to, or our office has delivered to the board secretary notice of publication and notice of service of all of the property owners located within 200 feet. And I would just like to confirm on the record that they have been received.
All right, thank you.
Okay, thank you.
Joe, if the gentlemen, or ladies or gentlemen that are intend to or may testify tonight, if we could have them stand up and just do a group swearing in.
Okay, David and Phil, just in case you have any questions, one of you want to stand, and you can be sworn in.
Just in case, just so we don't, just if you gentlemen raise your right hand, and you solemnly swear that the testimony you're about to give tonight to this board is truthful and accurate to the best of your knowledge. Okay, thank you.
Thank you. And Gary, you were just going through some of the areas that are still at issue, and perhaps Mr. Pettit's letter of November 15th. I think there are issues concerning the retaining walls, explaining the traffic pattern as a result of the additional parking spaces in the place.
Hey, Gary, why don't you just speak into the mic if we're taping this, please? Thank you.
Okay.
That would be attached matter carriage when they go to the diesel.
Okay.
Be like a rock star.
Yeah. Yeah, the proposal, as we said, is for additional parking. The only change in traffic pattern is on the east side of the existing building, where we would propose that this driveway would be one way out only, and we would put parallel parking along that driveway. The rest of the drive aisles will still function the same way as they always did. We're proposing additional paving in the locations that are shaded in, here and back here at the back of the site. And we're adding a couple handicap parking stalls because as we increase the number of total spaces on site, we need more handicap. So that's the major changes. In making those changes, we do have to install a couple retaining walls. They're not real tall type, but to hold back some of the slope that we have in this area, as well as relocation of a few trees. And we're installing a few new light fixtures in new parking areas. I have had a chance to review Mr. Pettit's review letter, and we are pretty much in agreement with everything. We wanted to discuss with the board one comment really only, and that was concerning sidewalks and the configuration of the sidewalks that are out there now versus what is in the letter. So that's the one I...
Well, I spoke to Mr. Pettit today, and he did convey to me that he had spoken to you, Gary, and that you had pretty much gone through his letter, and you were in agreement with everything. So I guess in the interest of time,
There's one issue.
Yeah.
That's what Gary just mentioned.
yeah, I was just saying if we could skip to that.
I'm sorry.
No, that's okay. That was unless any other members have questions.
Yeah. What did you skip?
No, everything on the letter, he agreed to. Everything on John's letter, Gary agreed to today, except for the sidewalks.
Okay. Okay, I didn't know that.
So John had thought that perhaps instead of him going through his whole engineering letter,
All right.
Dave agreed to it. So unless the board members had any specific questions other than the sidewalk, we could move forward.
The easement that you have, you said you gain access to your property through an easement?
Yes, the easement.
That's not going to change.
That's not changing and
Okay.
staying in its present location and configuration.
Thank you.
John, which issue are we gonna be discussing? What number on your
It's
letter?
number 3 at the bottom of page 3. And
Okay.
The question we raised was, with the addition of the new parking spaces, there isn't a pedestrian access from the spaces to the front door. Particular with the spaces being added in the front of the building here, can you just point out those areas there? There's only a portion of the existing site that has sidewalk in front. I believe based on my discussion with Gary today, that the parking on the left-hand side of the plan, that would be overflow.
Right.
So perhaps that's not being shown to be utilized as often. Personally, I think the spaces in front should have sidewalk.
So we're looking for some safety for pedestrian travel, basically.
And the grade is not changing that significantly, is it, John?
Not in that area,
The grade?
no. No, not in that area.
Okay. Thank you.
The one area that may be a little bit of concern just from the landscaping is there, and it is pretty mature landscaping, is maybe from here over to the corner where I have some pictures on the site that would show that. These other areas are more open and could be more easily placed.
We'll mark that as applicant exhibit 1. Applicant exhibit number 2.
And what they show is the area from this entrance here over to the side of the building, where we're talking about where there's some heavier landscaping and there's 2 shade trees that are in that location.
Thank you.
How do you expect people to walk on those parking spots?
Well, there's really no change in what's occurring on this end of the building, and that's the way it's straight now, that's the way it's been functioning, and it's a big problem. Over here, we are adding handicap, so it makes more sense to be placing a sidewalk in that location.
And John, can you point out where you were proposing to add the sidewalk, John?
We were looking along the front of the building.
Here, I guess here.
Yeah, yeah.
To this end. Yeah, this is the only area I see that.
Without sidewalk, you're getting into the car, walking behind the car, or walking over the grass.
So you're looking to extend the existing handicap sidewalk, basically?
There's a portion of sidewalk in front of the building now.
Right.
In front of some of the spaces.
Yeah, this
They're
is
expanding the number of spaces to the right-hand side there on the plan. So we thought that the sidewalk should at least continue where you're creating more parking spaces. The spaces to the left are existing, they don't have sidewalk now. You know, it's up to the board. I mean, it would be consistent to have sidewalk along all the spaces in front of the building, which is typical for commercial development.
So you're saying it should have been on there maybe originally, or was it really caught?
What I'm saying is, if this was coming in as a new application, 9 times out of 10, you have parking spaces with sidewalk in front that would provide you access to the front door.
Not a problem.
Well, it's really up to the board. Our thought was with the mature landscaping that exists, it hasn't been a problem since the building was originally built, will be sufficient addition to the new spaces. Again, it's the board's discretion, but we just feel that from a visual standpoint, from an aesthetic standpoint, there's been no safety issues the entire time it's been there. That we think that this would be an appropriate combination.
Well, personally, I think, just my opinion, I'd like to see the sidewalks go across the front of the building, only because this is an opportunity to do it now while we're adding the spaces, and I think it's definitely safer for the people, especially having handicapped people coming along there with their caregivers and whatnot. I think it would be appropriate to have the sidewalks. Any other questions from board members?
No, it just looks like from the picture that it may not interfere with that tree that's to the right of the entry. I can't tell because the photograph is straight along. It looks like if you were to extend the sidewalk the same depth as it is on the other side of the door, it may not affect that tree. At least for now, I don't know when it grows older, but
Anybody else?
But you're just asking that the 3 spots, just so, it seems that the applicant, Mr. Chairman, and members would put the sidewalk along the new proposed, but the 3 spots that were already approved, I guess without the sidewalk, they're asking that they can leave that the way it is, or the way it was originally approved. I think that's what you're saying, that you will put it along what you're proposing new.
Well, where the new handicap.
It's not shown on there, but apparently they would amend their,
We're talking about the 13 spots. You want to put it across the 13 spots, but not along the 4 spots that are going closer to your more densely landscaped area?
Yeah, we have walk already.
Correct. And you want to travel down the next 14?
These 4 and these 6 would have, in front, and they're the handicap spaces. But we're asking for this portion not to be put in.
Well, what about the ones after the removed existing restriping? You're showing 1, 2, 3, 4, 5, 6 more spots as you continue down that corner, exactly.
Yeah, all of it.
Okay, so that's a total of 14 spots, I think, on this plan. 1, 2, 3, 4, 5, 6, 7, 8, 9.
No.
No. So that makes sense.
Yeah,
13, yes.
But John, your recommendation is in front of all the parking spots on both sides?
You know, if the rest of them all have sidewalk, I would think it makes sense to put it in.
We're just trying to accommodate the existing landscape and not
36
impact
feet.
the bushes.
John, when you visited the site, did you see where the sidewalk would be encroaching upon the existing landscaping?
Well, looking at this photo, I think you could get sidewalk.
See the sidewalk in
Take
front.
one tree out.
Well, I guess we'll kind of pull the board. Mr. Ockley, do you want sidewalks across the entire frontage?
I think it'd be better.
Mr. Capados? Mayor?
yes.
I agree. Mr. Dickinson?
I don't see where it's necessary.
Okay. Mr. Bowman? Mr. Johnson?
Safety first.
It was the only issue.
I believe Mr. Sibley wants to bring up another issue about phasing the project.
there was an issue raised.
Please talk into the mic.
Oh, yes.
There was an issue raised regarding placement of the bond. And of course, as I indicated, we're not sure when the building will occur. And if and when it occurs, it would presumably be done in phases. So I just want to make sure that to the extent that the application is approved, that the resolution would indicate that it would be phased in, and as we apply for permits and gave a cost estimate, we would bond for that particular portion. We don't want to bond for the entire project because we're not entirely sure we're going to put in all 76 spots at the same time.
How is it going to be phased in?
What we would do is on the plan, we would depict each phase and list it in a chart as well as point each and call it its own phase. That way you'd know how many and what location is each phase, and that way when we bond it, we would say we're going to put in phase 3, for instance, and however many spots that was, then we would bond for that work that's involved in those spots.
But do you know how many phases it's going to be tonight?
Well, yes,
We
there's a
want that
total
in
of
the resolution, and we really
Well,
can't determine.
I think well, correct me if I'm wrong, but I think the resolution would say the project could be phased I can work that out with Gary's
Okay.
office. We would have to make sure each phase could act independently. Because if we say we're going to go phase 4, we want to make sure that that can act on its own. And if that's in a resolution, and it's clear on the plans that are signed off by the chairperson, then when it goes to the borough engineer, he'll know that each one can act independently and do independent estimates.
How many phases are you trying to do, Gary?
Well, there's a total of 7 that could occur. And the nice thing about this plan is each one of them does stand alone. They're not dependent upon one another functions. So we would break it down in chart form and also into each phase and number it. That way, whether it was phase 1 that was built first or phase 3, it would work, and it would also be monitored for that phase of the project.
John, from engineering standpoint, are you comfortable with that?
Comfortable as long as it's on the plan and it's clear, so when we go to the borough engineer's office, he knows what was approved.
Is everyone else on the board comfortable with that?
And I'll work it out with John so that we make sure that it is clear and acceptable.
That the phasing schedule will be right on your revised plan.
Exactly.
So now everything that
John, is this the amendment to a previous site plan, or this isn't? You're requesting a site plan for preliminary and fine, but they've already had a site plan for the building. There's already site plan approval for the existing part. Would this just be amended?
I haven't looked at it.
What was the approval for the
That's 7, I believe.
Yeah, 1998. We thought that, we considered that, and thought that we would just come in and complete the plan, show, it's all new area that we're expanding into, I thought that was appropriate to call the plan.
I don't know that it matters, Dave.
Yeah, as long as it doesn't, I mean, I might refer this to an amended, or an amended expanded site plan, or for parking, or, so you guys know.
Are there any other comments from these professionals? Any other questions from the board? All right, at this point in time, I'd like to take an opportunity to open the floor up to members of the public. Members of the public wishing to speak on this application and this application only, please come forward to the microphone, state your name and address, and be heard.
We don't quite, excuse me, Frank Carver. I don't think I need a mic, but everybody sitting back here hasn't had an opportunity to see what it is they're proposing. There's also been quite now a reference made to the existing building. What existing building are they talking about?
Mr. Powell, can you please give me your address? I'm sorry.
I'm sorry?
What is your address?
407 Sheffield Court.
Thank you.
You know, they're talking about a retaining wall. I don't know what that retaining wall is going to present as far as, you know, they're going to upset a lot of wildlife that exists back in that wooded area, and they're going to be roaming all over the place again, as they did
We're
before.
talking about the Richards Group, sir. This is on 9th Avenue. This is the Richards Group building.
This is the industrial park, Mr. Kaplan.
Oh, I'm sorry. I apologize.
No problem. That's fine. Is there anyone else wishing to speak about the Richards Group?
In fact,
Linda Herman, 213 Oak. I was unfamiliar with any of this until just now. We were talking about transferring trees. What size trees are you cutting down, or are you really transferring, or are you going to cut them down and replace them?
No, they're gonna be relocated. What size are they now, Darren? It's a
3
small-
inch.
So they're no huge,
No, they're not.
Smaller.
they're not big, so it's-
No, there's.
Thank you.
Thank you, Linda. Anyone else wishing to speak?
seeing no one else, I'd move that the public portion of the meeting be closed.
Second? Second. Okay, motion made by Mr. Dickinson, second by Mr. Wachowski. Jim, we have a roll call, please?
Leland,
Yes.
Dickinson,
Yes.
Bushian. Yes. Chowski,
Yes.
Walperly,
Yes.
Gunn,
Yes.
Valdez, Katadas,
What are we voting on?
We're voting on preliminary and final site plan approval for the DPE Richards Group.
Do we want to add the conditions?
We're gonna
They,
put,
they were on the record.
It's on the record,
Yeah.
conditions,
They're gonna-
7
they're gonna
phases.
put phased in up to 7 phases, if they're agreeing that the phase along the building, there will be sidewalk along the entire, building, which is new
Parking lot.
parking and the existing parking. They're gonna comply with all the points, and review comments contained in John's letter, that will be referenced in the resolution. Okay? There were no variances required.
okay, I declare this site plan approved. Congratulations, guys. Good to see you again, as always.
I don't have to say this, but now you'll make it nice.
You're welcome, guys.
Good to see you.
What's that? Wasn't there that thing was being- that was not perfect.
What's that, Bill?
Sorry for the brief delay, we're just explaining something to a resident. All right, thank you so much. The next matter of business we have on is the application for the Butler Group for major subdivision preliminary for block 129.01, lot 1. I just wanted to take a moment to kind of explain to the public what's going to transpire here. We are not going to bifurcate these proceedings. We are going to hear the matter in front of us tonight is the use variance / density variance. Until that is approved, nothing can even be discussed about the site plan, okay? So we'll be discussing the density ordinance only right now, okay? And then if that gets approved and we have time, we may move on to the site plan. Because this is a D variance, that means the mayor and the councilmatic seat must step down during these proceedings because they are the first right of appeal.
That's correct. Yes, Mayor and Nick.
I hope you feel better. Happy Thanksgiving.
Yeah, thank you. Happy
Yeah,
Thanksgiving.
if you guys just, if you want to hang out for the,
You got the kid.
no, Mr. Light had something to talk about regarding the fences, but I know you've been down that road. You go feel better. Yeah, we'll do that at the end then. Okay.
Good night, everyone.
Good night now. Okay. Now, I know we've all probably read this over and whatnot, but for the edification of the public, what I'd like to do is, first of all, read our ordinance that we have in place in Runnemede.
Well, Michelle, before you could first have Mr. Bannon introduce himself and his witnesses, and then swear any potential witnesses.
That's fine. Yep.
As a point of order. Jeff, your intended witnesses tonight that will be giving testimony?
Thank you, Madam Chairperson, members of the board. I'm Jeffrey Barron. I'm a licensed attorney in New Jersey, and I'm representing the Butler Group, which is the developer of this property. We have with us this evening an engineer. There he is. He'll spell his name and give you his name. We have a planner, Mr. Cuviello, who is going to stand up and come over and be sworn. We have Deanna Drum, who is the traffic engineer, who is going to be sworn. And I'll have Mr. Butler sworn, although I don't intend to take any positive testimony. If there are questions by the board, John is here to answer those. So those are our witnesses for this evening.
Folks, would you please raise your right hand? The testimony you're about to give this board today, you swear affirm that it will be truthful and accurate to the best of your knowledge. Thank you.
Before you sit down, can each of you spell your name for the record so it's clear, please?
Tiffany Cuviello, C-U-V as in Victor, I-E-L-L-O.
Deanna Drum, D-A-N-N-A, Drum, D-R-U-M-M.
Ahmad Moose, A-H-M-A-D-T-A-M-O-U-S.
John Butler, B-U-T-L-E-R.
Just like it says.
Thank you. All right, David, you want me to read?
Okay, yeah.
Okay.
So, educate the public.
Yeah. We just want to, for your edification, just so you know what the existing ordinance is in town, because we do have an existing ordinance referencing density. And the ordinance is 35-8. The purpose of the R3 zoning district is to provide medium-density residential areas on the periphery of the R1 residential district areas and to promote creative subdivision design that balances residential development with common open space. It is the intent of the R3 district to encourage clustered single-family and townhouse developments types, but also to acknowledge and permit existing multifamily developments within the zone. Permitted principal buildings, structures, and uses within the R3 district, only the following buildings, structures, and uses are permitted. Single-family detached dwellings, semi-detached dwelling, which are duplexes, townhouses, municipal buildings, structures, and uses owned or operated by Runnemede Borough, outdoor public or non-profit recreation, athletic fields, conservation area, and parks. Conditionally permitted uses within the R3 residential district for the following uses are permitted conditional uses. Continuing care retirement units in accordance with the standards set forth in 39-24C, including assisted living residences, nursing units, long-term care units, and congregate care independent age-restricted use. Accessory uses. Accessory uses must be incidental to the primary use. Accessory buildings may not be located within the front yard area. Corner lots have 2 front yards. Accessory buildings equal to or less than 200 square feet in the area must be set back a minimum of 5 feet from the side and rear property lines. Accessory structures larger than 200 square feet must meet the setback required for principal structures. The maximum height for accessory structures is 15 feet. Enclosed second stories are not permitted. The following accessory uses are permitted. Detached garage, maximum area is 720 square feet. The garage shall be set back a minimum of 60 feet from the front property line. Sheds, no more than 2 sheds are permitted in a residential lot. Fences and walls not exceeding 3 feet in height in the front yard and 6 feet in the rear yard. Residential swimming pools in accordance with borough requirements. Stormwater management facilities as regulated by the borough code. Bulk and area regulations for the R3 zoning district. The maximum permitted density is 3 residential units per gross acre. Okay? The base minimum lot size is 8,000 square feet per residential unit. Minimum lot size for stormwater management lots or open space lots is 20,000. Table of performance regulations is listed, and that pretty much in essence gives you a snapshot of what our existing resolution is, our existing zoning ordinance that we have in town now. And again, like I said, what we're going to do tonight is we are going to have the Butler Group and their professionals come up and give testimony regarding things such as the traffic study that they have performed and things that are going to affect the density variance. Nothing that's going to have to do with the site right now. We're not there yet. So we have to do one thing at a time. Like I said, it is a permitted use to have these townhouses. Our goal as a board is to find a fair and equitable plan that is good for the applicant and good for the town, that reflects the open space and things that we have set forth in our master plan. So with that, Jeffrey, I would defer to you. Good evening.
Good evening. I want to start out by saying that it is not my intention in this application to be adversarial. My job is to make sure that both we and you act within the law. And there is a problem with your ordinance, and I'm going to explain it to you in just a minute. There's a Supreme Court case that renders part of your ordinance invalid. And as a result of that, and you don't stand to determine the ordinance, that's done by your governing body. But in interpreting it, I think you have to understand, if Mr. Rowan agrees with my position, what the Supreme Court has said. This is an application for property by the Butler Group at the intersection of Evesham Road and Hartford Drive. That's block 149.01, lot 1, on the Runnemede Borough Tax Map. We are proposing a major subdivision, but I agree with what the chair said. In fact, I called the secretary, yes, my secretary called my secretary, and she had been conversing, and we said we would only be moving forward with the use variance, because I totally agree with the chair's position. If the not use variance, the density variance. If the density variance isn't granted, then obviously the plan that we're showing you couldn't be constructed. So we agree with that. This is not a use variance. This is a density variance. As a density variance under NJSA 40:50-70D5, the standard is not what you might be used to on a use variance, which is special reasons, inherently beneficial, particularly suited. The standard is established by the Coventry Square case, which was decided by the New Jersey Supreme Court more than 10 years ago. And that standard is really very simple. Because you zoned for it, all we need to prove to you is that what we are proposing can be accommodated without problems. So we're going to, and Ms. Cuviello will talk to you about that. We're going to talk about traffic because I am aware of what happened less than a year ago in front of your board when the applicant came in and there was a discussion of doing single-family residential. We'll explain to you, or I'll tell you right now, we can't do that. Single-family residential market is dead. It's not just dead in Runnemede, but it is. And there is no economic viability to that. Since townhouses are a permitted use, it is our client's desire to move forward with townhouses. Let me, if you would, go on with the ordinance. So you'll hear the Coventry Square standard, you'll hear from traffic, from drainage, from environmental. There are no problems with this site, no problems at all. There's 114 townhouses proposed and 5 open space lots. And the open space lots is where the problem comes in. Your ordinance under section 395.8 E is in Edward, permits the following, and the chair just read it. 3 units per acre. Minimum lot size 8,000 square feet per unit, per residential unit. Open space, minimum 20,000 square feet. In the New Jersey Supreme Court case of Sure Builders versus the Township of Jackson, the requirement of open space in ordinances was struck. And the only time it can be required is for a planned unit development, which this doesn't qualify for, or cluster. Now, interestingly, in your purpose, you say cluster, but there are no cluster provisions. You don't have any definition of cluster. You don't describe how a cluster would work, and so you can't do a cluster. Since open space can only be required for cluster or PUD, you can't have a requirement for open space. If you permit me, I'll just read from Professor Cox's book. I'm sure people read to you from this all the time. This is section 16-14.3 at page 448 of the 2013 edition of Professor Cox's book. And Professor Cox says the following. The fact that conservation of open space is one of the purposes of zoning in their citations indicates an intent by the legislature to provide for open space in appropriate locations for a wide variety of uses in favor of a broader reading of the municipal land use law allowing open space requirements in other zones. Following a close analysis of the relevant statutes, the Supreme Court in Sure Builders Township of Jackson 401 NJ 152, Abdiv Television, 2008, affirmed Supreme Court 199, New Jersey 499, 2009, only 4 years ago, concluded that the purposes of the MEOL do not provide local governments with the authority to require a developer to set aside common open space or recreational areas in projects other than planned developments without compensating the developer. It really means you pay us to do it. I suspect you're not interested in that. That's why it makes it difficult to proceed with the density under the standards of your ordinance. Frankly, it doesn't make sense, which you'll hear from our planners. I'm arguing, so don't take anything I say as being gospel, because the only person who believes that is me. But I do want you to understand the premise that we come from, and it's the following. It makes no sense, and you'll hear why, that you would limit a townhouse to an 8,000 square foot lot. Now, you're smart folks, so you really can figure this out for yourself. If it was a single family building, it makes sense, 8,000 square feet. If it's a townhouse, it makes no sense. You're going to hear Ms. Cuviella tell you, when you take out the townhouse, what's surrounding, which is open space, how much of a percentage that is of that lot. And I will tell you, there is not an ordinance in the state of New Jersey that would permit the amount of open space that you end up with. It's incredible. Now, it may be that what was intended by the ordinance is that a grouping of townhouses could be on a lot of 8,000 square feet. And that kind of makes sense. Kind of makes sense to me. It also makes sense because you allow duplexes. Now, I could understand on an 8,000 square foot lot, you intended to permit 2 units. In other words, 4,000 square feet for each unit. That makes sense. Townhouses, you know, are smaller. So it makes sense to me that there would be 3 townhouses permitted in 8,000 square feet. Now, even that would yield a tremendous density because you could get 5 of those 8,000 square foot lots. You'd end up with 10 townhouses per unit. We're not requesting that. The density that we're requesting is approximately 6 units per acre. And you will hear Ms. Cuviella tell you that she has looked at surrounding municipalities here to Runnemede, and she'll tell you what she found as density, which I think is instructive, does not compel you to do the same thing as they do. But I think it's instructive as to what other municipalities are doing in this area with density. That's, I think, all I need to say. I hope that when you hear the testimony of the applicants, you'll see that it's consistent with what I just explained to you. We have our engineer who will explain the plan I really want to do this for the public. We don't need to do this for the density, but I'd like them to understand how it's planned and what the ideas are here. And then I'm going to have Ms. Drum, who's our traffic expert, talk to you about traffic. She's done 2 studies. She's done a study early on before school, and then she repeated the study after school. You'll hear what the results of those were. And then we'll have Ms. Cuviello talk to you about the actual density variance. So, Madam Chair, with your permission, I'd like to call our engineer.
So, Mr. Barron, thank you.
Have you ever testified in the Borough of Runnemede before?
I am.
All right. And have you been qualified as an expert in engineering?
I am.
Madam Chairperson, unless something's changed in board composition, we request that he be accepted as a professional.
I think we'll accept him as a professional engineer.
Thank you.
Welcome.
Thank you.
Ma'am, if you would be kind enough, and I want you to speak up, because I want to make sure everything is on the tape. Could you come on up here? I'm not important, you are. On Exhibit A, which I have marked November 20, 2013, Mr. Rowan, if that's permissible, I've already pre-marked that exhibit.
That's fine.
Thank you. Could you explain to the board, first of all, what was your function in the preparation of the plan that you have on the board?
We evaluated the existing condition of the sites and evaluated the drainage, and we came up with the proposed layout for the proposed development in front of you. As Mr. Barron stated before, we were in front of the board previously, around November, December of last year, with a different applicant, different application for single-family homes. This is the same property. It's approximately 18 acres in size. We are proposing 114 townhomes for the property. Currently, the property is vacant. There are several utilities that traverse the existing property, mainly water and sewer active line from the apartment building that discharges into an existing pump station located on the east corner of the property. The access to that pump station, we're maintaining that access. We're not interfering with that access to the sewer authority. What we are proposing is to redirect the utilities through our system and direct it to the proposed pump station. To the north of the property, we have residential properties. To the west, we have the apartment complex, and to the north would be Parkview Drive. Yeah. The water tower and vacant land is to the east. We do have some sensitive environmental areas along that side. We are not disturbing. Our stormwater management is located in the east corner of the property. The runoff from the site and from a portion of the surrounding properties will be collected through our stormwater management system and directed to the detention basin. And what that is it has a sand bottom to allow for soil filtration to meet the state requirements, but it has an outer structure that discharges the flow at a controlled rate, lower rate than what's currently being generated, which is required by the state. Access for the property is one main access through Hartford Drive. The access is 30 foot wide. There are RSIS parking on both sides of the streets are permitted for the RSIS. We're only proposing parking on only on one side. The units have accommodate 2 cars, one in the garage and one in the driveway. RSIS calls for 2.5 units, 2.5 cars per unit, which is accommodated through the units and the parking on the street.
And I assume that the parking on the street will be on the side opposite the buildings.
Correct. I mean, one user requires on one side. And we'll work with the borough on which side the parking is to be on.
I just want to go over the stormwater for a moment, because that could be considered a problem under Coventry Square, so it's important, I think, for us to discuss it. Mr. Pettit has a number of detailed concerns about stormwater, which would have to be addressed at the time of subdivision approval if we get there. But from the standpoint of compliance with the state stormwater management and stormwater design standards, as a professional engineer, is it your opinion that the proposal being given to the board for this basin will be compliant?
It is. And John and I, we spoke, and I understand he does have numerous comments. However, we feel that we could work the issues amongst ourselves once the density issue, the hearing is resolved, engineering issues we could come maybe with Mr. Bennett and ourselves.
Okay, but you have designed it to satisfy the state criteria, which has been adopted by Runnemede as required by the state in its ordinances.
Yes, we did.
Okay. I have nothing further from our engineer. If the board has any questions, we're happy to answer them. If you want to wait until we finish our testimony, whatever your preference.
I'm fine. Anyone have any questions right this second?
Jeff, how big are these townhouses going to be? I noticed one of your submissions, 4 bedrooms and 2.5 baths?
I don't know how they're going to be 4 bedrooms, Dave, because they're 1,190 square feet. So I don't know how you get 4 bedrooms in that.
Oh,
But-
because I saw
but-
on one of your,
Well, we'd be happy to address that at the time of site plan. I mean, the application does say 1190, and I've never seen, there's a lot of things I haven't seen in regards to this application. One thing I've never seen is a 4-bedroom townhouse of 1,190 square feet.
Okay.
So it's not likely it's going to be.
500
but-
square, 600 square foot per floor.
Right, it's not like.
Tiny bedroom.
Yeah, so we'll address that at the time we come in for site plan. It's a very good question. I saw it as I went over the app tonight, and I thought, this can't be accurate. But we don't have floor plan specs at the present time, so that's why it's a little difficult to answer. But if we are able to get the density variance, I'll be happy to address that. Yes, they will. Each unit will have a garage, Mr. Pettit.
So 1 off-street parking space plus 1 garage.
Which will be deed restricted as the board requires to ensure that that parking space remains for that purpose and no other purpose.
As far as we're going to derestrict it so they can't make it into a bedroom.
You can't make it into a bedroom, they can't put storage in
Okay.
there, they have to be able to keep it open for a car.
Right, okay, thank
So
you.
you will meet the RSIS requirements for parking.
Yes, between the combination of the on-site and the off-site parking that's being provided, we meet the requirement. The board has no questions, I'll bring up Ms. Strong.
Thank you, Mr. Towns.
Ms. Strong, have you ever been qualified as an expert before this board?
For this board now,
Oh, great, well, we're going to have an opportunity to see if you can. First of all, would you tell us by whom you're employed?
I'm employed with traffic, planning and design in Camden, New Jersey.
And what licenses do you hold in the state of New Jersey?
In the state of New Jersey, I hold a professional engineer's license, again, specializing in traffic and transportation engineering in New Jersey.
Nobody's going to believe this looking at you, but how many years have you been doing this, Ms. Strong?
20 years.
Okay. You've testified before numerous planning and zoning boards in the state of New Jersey and been recognized as an expert in the area of traffic engineering.
I have.
Thank you. Madam Chair, we'd like to present Ms. Strong as an expert in the area of traffic engineering for the.
I think we have, also wanted to thank you for your promptness in getting the second counts that we asked for. I truly appreciate that. You were very diligent in getting that done quickly for us. And Mr. Pettit has certainly spoke very highly of you, so I think we can deem you an expert in the field without objection.
Thank you.
Please speak very highly, Mr. Pettit. Ms. Strong, if you would be kind enough to tell us, what was your function in regard to this project? What was it that you were asked to do?
My function was to prepare a traffic impact study to take a look at basically the area intersections in relation to capacity and the impact that this development may have or may not have on those intersections.
Am I correct that you took counts of traffic currently existing at the various intersections, both the intersection of this site with the main street that it connects to, also Evesham, you also looked at Davis, to be able to obtain back what we might call background information as to how much traffic is currently occurring, is that correct?
That is correct.
And after doing, and those counts are in the report, is that correct?
Yes, we have 2 reports.
That's true, changes in a second. I want to try to make this simple, more for the public than for the board. I don't intend to tell you the counts at every single intersection, because I'm not sure it means anything. But what I would like to tell you is, based upon the work that Ms. Drum has done, what's the level of service? I'll have her explain level of service. I know you understand, but I'd like to make sure the public does. Deanna, the counts that you did at these various locations, they are utilized to determine in part the level of service of each of the roadways. That is, the levels from A to F that each road is currently functioning. Is that correct?
That is correct.
Now, A, not unlike school, is excellent, and F isn't so good.
That is correct.
Okay. Are any of these roads operating at a level of service of C or lower?
The only intersection that has a level of service C is the Hartford Road approach to Evesham Road, which is level service C. That's the lowest operating conditions that we will have.
Okay. Would you talk about the other intersections and what their level of service are, please?
Certainly. The intersection of Hartford Road and Davis, which again is an all-way stop, that's a level service A. The intersection again of Evesham Road and Hartford Road, Evesham Road has a little bit better level of service just because it has more green time. Again, that intersection on Evesham is going to function at level service A. And again, Hartford Drive itself, the approach to the left turn, is a level service C.
Now, when you say that it operates at a level of service A because of green time, does that mean that the light that is located there allows traffic to flow, and so the traffic does not back up and become stagnant?
Correct.
Okay.
Yes.
So, from the information that you gathered, and were you...
Excuse me, can you take the mic out and stand on? We'll be back here.
Yeah, they can't hear you back there. No.
They're mumbling.
Who's mumbling, me or her?
Both of you, it goes in and out. You take it out of there.
It'll be closer to the mic, please. So from a traffic analysis standpoint, you use the counts to determine how many trips are occurring during peak hours, correct? Well, occurring altogether, but peak hours as well.
We use the existing counts to determine how much traffic is on the adjacent roadways. To determine how much traffic is being generated by the development, we use empirical data.
Let's talk about that. Let's talk about the empirical data that was used and what that empirical data indicated in terms of the trips which would be generated by this development were it to be approved as proposed.
Yeah, the empirical data we utilize is from the Institute of Transportation Engineers. It's a publication called Trip Generation. It's basically a real-time trip generation data that firms like myself or other firms actually go out, study, they compile it, and then again, it's empirical data. They basically average it. And again, we use that to develop how much traffic is going to be generated. There's different variables that you can use for different land uses. For example, retail, you use square footage. For residential units, you would use the number of homes. For the townhouse development, the 114 units, that'll generate about 60 trips in the morning. Again, trips are a vehicle coming out or a vehicle coming in. So it's 60 vehicles. Use vehicles versus trips. 60 vehicles in the morning, and it increases in the afternoon to about 70. And again, that's during a 1 hour time frame, which is typically when the greatest amount of traffic that is generated by a residential development.
So in the morning hour, during a whole hour, there are only, in my view, only 60 trips in and out, correct?
Correct.
So if you were to divide it by 60, you'd say every minute somebody comes in and out.
That is correct.
Now, how about in the afternoon? What is that trip generation?
It's just shy of 70.
Okay, so again, a little bit more than one every minute, but relatively close to the morning information.
Yes.
Now, that information, that's empirical, so it remains the same. But the counts that you had at the intersection, you did at 2 separate times, correct?
We did. We did it in August, and we just did recently in November.
Let's talk first about August. Were the levels of service the same in August at the intersection as they were in your most recent November?
Yes. Yes, they were.
All right, so no change in level of service.
No.
But there is a little bit more traffic at, I believe it's Evesham and Davis, is that correct?
No, it was Davis and Hartford.
Davis and Hartford, I'm
Yeah,
sorry.
particularly in the morning.
All right, and can you tell us what the difference is in trip generation, existing background, the trips in the second step?
I've had to refer to my notes, so.
25% higher.
It was 25% higher in the morning at Davis and Hartford. In the afternoon at Davis and Hartford, and at Evesham and Hartford, it was about within 5%. 5% lower, 5% higher. The biggest change again was at Davis and Hartford, which is about 25% higher in the morning.
How did you do the trip generation count?
Are you talking about the manual counts or the empirical trip generation?
I'm talking about the manual. Empirically, you can explain. I want everyone to understand how you know what's going down those roads to the intersection.
We physically have somebody out there that actually counts a car when it goes straight, when it makes a left, when it makes a right turn. We count for 2 hours in the morning and 2 hours in the afternoon, from 7 to 9 and 4 to 6.
And that person gives that data to you, you inspect it to make sure that it's accurate.
Excuse me, Jeff, does somebody have a cell phone on?
It's actually my alarm going off, my apologies.
Okay, I don't know if it's affecting the pickup on the tape. It's okay.
Folks, and I apologize, Messenger, I don't mean to preempt you, but could you please direct the public to either turn off or put their cell phones on vibrate?
My apologies, it was on vibrate.
Did everyone hear Jeff's request? We would request that everyone put any of their electronic devices on silent at this time, please. Thank you.
I don't even know how to answer the call, and we have an emergency at our house, that's why my phone was ringing.
I have no problem. I would just ask that if you do get a call of that nature, if you would please go out of the hall so that it doesn't affect the record being created on tape. Thank you so much.
Tell your engineers to do the same thing then.
Deanna, let me ask you a couple of opinions. First of all, as a traffic engineer, based upon the data that you collected, trip generation and the empirical data, do you have an opinion as to whether or not the ingress and egress that is designed for this site is within the standards of the industry to be satisfactory?
Absolutely. It is located in a proper location along Hartford Road. It also meets RSIS criteria. So yes, it does meet both RSIS standards as well as nationally recognized standards.
Now, I want to ask you about a standard from the municipal land use law, which must be satisfied by every applicant. That's for both the positive criteria and the negative criteria. This specifically is one of the negative criteria, and it is under NJSA 40:55D-70, the general standard at the end. And it says that there must be no substantial detriment to the public good. Are you familiar with the meaning of that provision?
Yes, I am.
Have you testified previously on other applications as to that provision?
Yes.
In your opinion, as a professional traffic engineer, is there any substantial detriment to the public good that would occur as a result of the design or function of the traffic improvements proposed in this plan?
My professional opinion is there will not be a substantial detriment. Again, it's substantial. I will stand up in front of every board and I always say, you take a vacant piece of ground and you develop, there will be an impact. But the question is whether or not it's a substantial impact. My professional opinion is that it's not a substantial impact. One of the reasons why is if you look at the area intersections, there's sufficient capacity to accommodate the traffic that's going to be generated. And secondarily, that the access in and of itself, where it's located and designed, meets nationwide standards as well as the statewide standards.
And included in that is the fact that of the 3 intersections, 2 will continue to function at A, the best standard, and 1 will function at C, which is in the middle.
Correct.
Thank you. Madam Chair, I have nothing further from Ms. John. If any of the members of the board have any questions to Mr. Pettit, we'll have the answer.
Anybody? Thank you, Ms. Strong.
Thank you.
You're welcome.
I'd like to introduce Tiffany Cuviello, who I know has not testified before this board before. Oh, you have?
It's about a year or so for running.
Toyota?
Oh, I apologize. Well, then, I hope you will accept her despite my lack of knowledge, because I didn't do that application.
You will accept her as an expert in planning without objection?
Thank you very much.
You're welcome.
Tiffany, can you tell us what you did in regard to your planning analysis of this project?
Yes, sir. I went and visited the property. I reviewed the application materials, your engineer's report, your ordinance, and your master plan.
Did you also review the traffic impact study that had been done by the firm?
Yes.
Okay. Based upon that, your analysis was really as to a density variance, is that correct?
Yes.
And can you explain to us what it is that you concluded and from what materials, please?
What I did is I looked at the various densities in your ordinance. I looked at your ordinance standards and the density of the surrounding development, as well as looked at other towns in the surrounding area and their ordinances in terms of density and other regulations that would impact appropriate densities for townhouse development or residential development, such as the state plan and affordable housing guidelines in the state.
Now, let's start with the basics. You read the ordinance, correct?
Yes.
Now, in your reading of the ordinance, can you tell us, you've already heard me talk about the open space issue, the Jackson Township case. Is it your understanding that for development of this type, open space cannot be required?
Correct. Under the findings in the Jackson Township case, open space is only allowed as a required set aside if it is part of a planned unit development or if it is part of a cluster development, neither of which your ordinance provides for in this zoning district or on this property.
Let's just be clear. Although the purpose of the R3 zone suggests cluster townhouse, there is no definition of cluster in the ordinance, is there?
No, there is not.
And there are no provisions explaining how a cluster would be done or what percentage of open space would be required for a cluster, is there?
None that I was able to locate.
So from a planning standpoint, absent that information, you couldn't plan nor approve consistency with a cluster, could you?
Correct. We did not develop this as a cluster development because there's nothing used as a standard for cluster development. In addition to that, in terms of a guideline of what cluster development is, the municipal land use law was recently amended to define a cluster development. And cluster development, under that definition, includes a greater concentration of density or intensity of land use than authorized within the sections under conventional development. And if you look at your ordinance, you only have one density of 3 units per acre, which is not consistent necessarily with your minimum lot size. And there is no bonus or increased density that would imply cluster development was appropriate.
Let's follow that a little bit further. The standard interpretation of cluster is that by setting aside a significant amount, some amount of open space, you're entitled to get a density bonus and more units, correct?
Correct, and the trade-off is the permanent preservation of open space.
But that isn't in this ordinance.
It is not.
Okay. Now, we now know that the cluster suggestion can't be applicable. Let's talk about the density that's provided in the ordinance, and from your research and in your opinion, is that reasonable?
The density is specifically stated in the R3 zone as 3 units per acre. If you were to develop this property with townhouses at 3 units per acre, you would get approximately 54 units. When you look at the surrounding densities in the surrounding area, your base lot size of 8,000 square feet creates what's called an implied density. That is, if every 8,000 square feet you had a residential unit within an acre, how many units would that be? And that's an implied density of 5.4 units per acre. I reference that because the surrounding lots in the area range for the single-family development off of to the west of the property, range in size from 7,000 to 8,000 square feet as an average, which would have an implied density of 5.4 units per acre.
You're speaking of units not within your development?
Not within the surrounding area.
Just want to clarify that.
The surrounding residential development has a general density of about 5 units per acre, 5.4 units per acre, assuming an 8,000 square foot average lot size. Checking tax records and tax maps to verify that the lot
When
size.
you say surrounding, are you meaning the borough of Runnemede?
I'm talking
Or Gloucester Township?
in Runnemede, yes. Yes, I focused that density of
Does
the.
not apply to the township.
I did not verify the densities in the other townships because I was comparing them with your ordinance and the area that is directly across Hartford Drive, or Hartford from the access point.
Are you including like multiple family dwellings as well?
No, and I did look at the adjoining residential apartment complex as well to determine what the density was there. And that complex has 224 units on approximately 12 acres, which is a density of 18.6 units per acre, much higher than what is permitted in your ordinance.
The purpose of the ordinance for the R3 recognizes such high densities immediately adjacent and indicates that, for lack of a better word, they're grandfathered, they're recognized and permitted, and that the use of other grounds is intended to be, it doesn't use the word compatible, but from a planning standpoint, intended to work with those very, very high densities of apartments, correct?
Unique to the R3 district in difference to your R1 and R2 district is a purpose statement. And that purpose statement includes an acknowledgement of and permission for the existing multifamily developments within the zone. It also designates the zone as a medium-density residential area for single-family and townhouse development.
Now,
I have a question. Did you use 18 acres in your calculation? Did you use 15 acres, which has yet to be determined how much of your 18 acres is developable?
Your ordinance talks about units per gross acre. So when I did the calculation of density on our property, I used the 18.2 acres, which is the gross acres, based upon the fact that the ordinance, when it talks about density, specifically says 3 dwelling units per gross acre, which would mean the entire tract
I
without
think you
any.
can only build on 15 acres.
the state is, again,
Why is 18 acres acceptable?
I don't want to be argumentative. I will simply tell you that you are not able to create a standard that runs in conflict with the municipal land use law. The municipal land use law defines density as the amount of units in a gross acre.
I'm not determining that.
Let me finish. Let me
I'm
finish.
making reference to it, a point that Mr.
I know. I understand what you're doing. You cannot extract anything from the overall size of the tract when you're computing density. It is based on the overall size of the tract. There are other things that might be affected as to subdivision standards when you get into that, but not for the basis of density or use. You cannot remove those.
So the
I'm
proposed,
sorry, does that answer your question? I didn't mean to cut you. Thank you, sir.
and to figure out back where I was, the proposed density that we're requesting is 114 units on the 18.2 acres, which is 6.25 units per acre. We believe that that is within the general range of the surrounding densities. And to give you one more point of reference and perspective for development in the borough of Runnemede, just to the top of the plan, you see these homes. That's a townhouse development that was constructed in 1996. It's Otter Branch Creek Townhouse Development. It is 24 units, and the density over there is 5.2 units per acre. So again, higher than the 3 units per acre, and not generally inconsistent with the surrounding area. The difference with that is it's not as close to the higher density apartments, which directly abut our property, which is 18.
I think it's Barrington, if I'm not mistaken.
Magnolia.
Or Magnolia, yeah.
Otter Branch is Runnemede. I was in your tax assessment record.
Kimberly Drive.
Kimberly Drive.
Kimberly
yes,
Drive,
yes,
okay.
yes. Yeah, I checked your tax records.
Gotcha.
If they were in there, then there's something seriously wrong with the tax record.
Ms. Goodfellow, just so it's clear for the record, what you were just pointing to has been marked Exhibit A1, and when you say at the top, you mean at the top part of that exhibit where there are some multifamily units that don't completely show, but a portion of them show?
Correct.
Okay.
And that is Kimberly Drive for reference.
Yep.
So we believe the density that we're proposing at 6.25 units per acre is not inconsistent with the surrounding densities. And I want to talk briefly, before I get too much far gone from the density requirements, the problems with your ordinance in terms of trying to understand how to develop with the 3 units per acre on an 8,000 square foot lot and the open space requirements. What you have in your ordinance is the conflict. The 3 dwelling units per acre would really result in a lot size of approximately 14,000 square feet. The minimum lot size requirement is 8,000 square feet. When you read the base minimum lot size, 8,000 square feet per residential unit. So what that tells me is that you expect a townhouse, a single townhouse unit, which is generally 18 to 20 feet wide, to sit on an 8,000 square foot lot. And that doesn't seem to make much sense because you don't see a townhouse that's 8,000 square, on an 8,000 square foot lot. Because townhouses are 18 to 20 units wide, and your definition for a townhouse, which is consistent with the definition for a townhouse in many planning documents and many ordinances, is 3 or more attached houses in a row with party walls. So essentially what your ordinance contemplates as a townhouse is at least 3 units attached, 1 middle unit, 2 end units, or more. And if you were to put 3 or more units, each of those units on an 8,000 square foot lot, that center unit would have to be pretty large, because you would have to at least have the 80-foot width if you're looking at an 80 by 100 lot. So you'd have a center unit of 80 feet wide, and then the 2 end units. It doesn't make much sense.
Have you ever seen a house 80 foot wide in any development in New Jersey that you have either testified on or sat on a board for, Ms. Cookiel?
I have not seen, although stranger things can happen. There may be something out there somewhere else, but in the years that I've been doing this, and I've been doing this for 18 years, I've never seen development with a townhouse of 80 feet wide or on an 8,000 square foot lot. I have, however, seen the location of townhouse buildings on an 8,000 square foot lot. And I think it's important to say, well, if your ordinance contemplated that it meant an 8,000 square foot lot for 3 or more units, at a density of 3 units per acre, you could get 3 townhouses on 8,000 square feet, and the balance of that acre would then be used as open space, which would be an 81% set aside for open space, which is also a very high percentage for open space set aside.
Have you ever seen it set aside more than 50%?
I may have seen 60% with an intense cluster type development, but 81% open space is very extensive.
And as you testified before, after Jackson Township, the board can't require such open space.
Correct. And so, just to make that clear, if I had an 8,000 square foot lot and I put 3 units on it, because you're allowed 3 units per acre if I'm reading your ordinance as it is strictly written, I am now with the 8,000 square feet minus the 43,560, which is how much an acre is. The balance of land left in that acre is 35,560 square feet, which is 81% set aside for open space out of that full acre. Just so that I made that note clear. So the problem we have with the ordinance is it's missing something. It doesn't make sense for the townhouse development to be constructed in that fashion. And with the provision of the Jackson case, any set aside of open space is not appropriate. And even if this were a cluster development, an 81% set aside of open space would be exorbitant in and of itself.
What set aside space are you guys proposing?
We don't have, we have open space of, just give me 1 second. Where did I put that? Oh, I think I have it.
15%? Just under 15%.
The actual open space of the site, Madam Chair, and I apologize, the engineer gave me that calculation at my request, is just under 15%. It's not required in your ordinance, but we are providing 15%.
Just trying to get a feel for it.
I understand.
That includes the retention basin, Jeff?
Yes.
All right.
Okay, so that aside and how you read and understand the ordinance and what it says, we wanted to provide a density that made sense for the property. and that was consistent with the character of the area, not as high as the apartments, a little bit higher than the residential single-family because in its nature, townhouses are generally a little higher density than single-family units are. And so the 114 units at a density of 6.25 units per acre is a density that I believe is appropriate for townhouse development in this area and is also consistent with other densities for townhouse development in the surrounding area and in accordance with what's recommended in the state plan by virtue of that through affordable housing regulations which have implied densities. When you don't know what the answer is, you look at all the other regulations to see what everyone else is doing. So just for some reference, I looked at the surrounding municipalities, none of which specifically permit townhouses except for Deptford Township. Deptford Township permits a density of 6 units per acre up to 10 units per acre. Being that none of the other surrounding municipalities had a specific provision for townhouses, I went a little further out to more developing municipalities, and I went to Washington Township, which isn't that far as well, and they permit up to 10 units per acre as well. To further that, I went and I looked at what the state planning designations through the presumptive densities for realistic development potential would be used under the affordable housing regulations. You are in what is known as a planning area 1 under the state plan. Runnemede is a growth area, and that is 8 units per acre. You are also near a planning area 2, which is more suburban, and that presumptive density would be 6 units per acre. So generally speaking, the 6.25 units per acre that we are proposing is not only consistent with the community that's around you, it's also consistent with, and in some cases less than, the densities that are prescribed in nearby communities and less than the prescribed realistic development potential densities that the state uses in determining what's appropriate for development. I will note, and I think you should, you have 2 other residential zoning districts in town. Your R1 zone, which permits 6,000 square foot lots. If you calculate what that density would be, because you don't have a specific density listed, it's 7.26 units per acre, which is higher than what we're proposing for the townhouses. You have your R2 district, which is a 20,000 square foot lot, which is obviously a much lower density. That's 2.178 units per acre. And when we look at the R3 zone, while it prescribes 3 units per acre specifically, the implied of the 8,000 square feet is 5.44 units per acre. I referenced the 2.17 as your lowest density and the 7.26 as your highest density, and recognize that in the purposes of the R3 zone, it's set out to be a medium density zone. And we believe that the 6.25 units per acre falls within that medium range as well. So there's another barometer for which you can look at in terms of why we feel this density is appropriate on this property.
If you think you've covered everything, and I'll give you a minute to check, I'd like you to talk about Coventry Square.
In terms of why we feel the density is appropriate, I think I've gotten that far. I do want to provide some additional information for you, because while I'm talking about all these numbers, what I'm not doing, and I'm giving you background and facts, what I'm not doing is really touching on the D5 variance criteria, which is I think what you would like me to do with the Coventry Square. So now I'm going to tie this all back into why, as a professional planner, I believe that you are able to grant the density variance. A density variance is not an outright use variance. It's not one where we have to determine particular suitability, because the property is already zoned to permit townhouse development. What we have to do is what is called the Coventry Square standard. It's a lower standard, still requiring the 5 affirmative votes because it does impact intensity of development. But the standard is somewhat lower because we only have to demonstrate to you that the site will accommodate the development as proposed at the higher density. In this instance, like I indicated, it's very difficult to try to understand what is meant by density of development, because when you permit the townhouses, your ordinance provides very many confusion around what that density would be and what would realistically be developed for a townhouse development. So, as I indicated, we believe the 6.25 units per acre is consistent with the character of the area and not, while it's substantially less density than the apartments, it lets the apartments help dictate what is appropriate in this area. We believe also that there is a need for townhouse units in the borough of Runnemede and a need for new housing. In accordance with the 2010 census data, your housing stock, you have about 3,400 housing units, 3,454, according to the 2010 census data. 78% of those units were built prior to 1959. You have an old housing stock, which is probably no surprise to anyone in this room. That being said, 70% of your housing stock is single-family detached units. So while you have some multifamily apartments, you have a considerable number of single-family apartments. You do not have many townhouse units, and the newest townhouses, and really the only townhouse development that I saw was on Kimberly Road, and that's 24 townhouse units of your total housing stock. So we believe that there is a need for a variety and mix of housing type in the borough, as well as some newer housing stock to be added into the borough. I reference that because while I'm dealing with this D variance, I have to address the positive criteria. I don't necessarily have to address the particular suitability, but I have to demonstrate to you that there are some purposes of zoning that are advanced in terms of this application and this density.
And if I could just interrupt you for 1 second, you stopped and said the variation of different housing, and that is something in my mind. Was there a reason why you guys decided to not incorporate anything but townhouses in this plan? In other words, is there, like, the plan we had originally, before you were approved, had some townhouses, some clusters, some single family. Then you guys came back with Ralph Ford. I don't know that you were with Ralph. Ralph was the planner at the time. When you came back with Ralph Ford, he got rid of everything but the single family. So that was kind of a monotone development. And now we're going back to one size fits all. Just wondering why we can give any consideration to having, you know, Chevys and Toyotas and Cadillacs on the same lot so that the people coming to Runnemede would have a choice rather than just be herded into a townhouse or nothing.
It's a good question, and the answer is, if there were an analogy, when Toyota had its problems and people stopped buying Toyotas, they stopped buying single-family detached housing out of share. There is no market for it. There just isn't, and especially in Runnemede, there isn't, because the price point would destroy your existing single-family sales. You wouldn't be able to sell an existing home. So we looked at what is currently selling. To be absolutely candid with you, my client wanted to do apartments and much more in terms of number, but that's a use variance. And I suggested that we would be better served if we were to come before the board with a permitted use, with a density that we believe is reasonable, and then to work on the bulk standards. Because obviously your bulk standards are based on your lot size. So with an 8,000 square foot lot size, your side yards are very large. With a townhouse, there aren't side yards.
Right.
They're attached. So the answer to your question is, we looked for a product that we knew would be viable economically, market share. We looked for a product that is needed in this town. You just heard Ms. Cuviello's testimony. You don't have many townhouses. I can tell you the truth. You could have hundreds more and probably come into conformance with what most towns have as percentages of single-family townhouses, duplexes, multifamily apartments, or condominiums. So it was our view, and if you've heard Ms. Cuviello testify, this is a reasonable use in the zone where you recognize the heavy density of the apartments and the surrounding uses with a somewhat lesser density. This isn't a whole lot more density. So it is proposing a product that the market currently is interested in.
Have you established a median price for your units as of yet?
We have not.
Okay, thank
We
you.
have not, and I will be
No problem.
happy to address that at the time of subdivision.
Sure.
Again, I would be talking out of both sides of my mouth if I told you a few minutes ago it can't be 4 bedrooms and 1190 and 1190, but then I told you, but we know what it's going to cost.
Right.
It'd be silly. if I gave that testimony, if you even believe me.
No problem.
Okay, thank you.
You're welcome.
I'm not testifying. I never.
So, back to where I was, give me a second to reorient here. I was talking about the variation of housing that this would provide in the community and why it promotes the purpose of zoning. I want to go back also real quick and state that this is the only zone that permits townhouses, and it's in the purpose that it should permit townhouses. And so under the purposes of zoning, which are in your municipal land use law, while we don't have to address the particular suitability, I believe that this site promotes two purposes of zoning. One is that it provides an appropriate population density because given the surrounding densities and given the proposed density and other potential and common densities for townhouse development, the 6.25 units per acre is an appropriate population density for this site, which is the purpose of zoning. I also believe that this site and this development provides sufficient space in an appropriate location for a variety of uses, and in this instance, that being the variety of housing units. And Madam Chairperson, you indicated that why wouldn't we have a mix of units? One of the things as a planner I find very difficult to understand is why we stop at property lines. When you look at this plan, you have a mix of uses. You have that mixed use opportunity. You have apartments, you have townhouses, and you have single family units at varying sizes. And what I didn't do when I started this presentation, which I usually do, but Mr. Barron got me going on the ordinances, is describe where we're located. And this property is at the intersection of Hartford and Evesham Road. And if you look at the plan that's up here, Exhibit A1, to make the attorney happy, to the west of the plan, or the bottom of the plan, is your shopping center where your food market is. And just below that is the Board of Education properties. Your schools are located nearby. So this property is located in an area that's within reasonable walking distance to your commercial on Evesham Road. And it also provides that mixed use that you're talking about, just not within the property confines.
Within your property.
Right.
Yeah, I'm talking about within your property.
I understand that's what you're talking about. I was saying as a planner, I'd like to try to look outside the property line and say, how does this fit in and what is this mixed use? And there is a mixed use here. It's just not within our property boundaries.
Correct.
So for that reason, I believe it provides sufficient space in an appropriate location. We also have to address what the potential problems are from this application, because as I indicated, the standard is that we have to demonstrate that the site can accommodate any of the problems associated with this development. That's why you heard some from our engineer and some from our traffic engineer regarding those impacts. This is part of the negative criteria aspect, which is that I have to demonstrate that there's no substantial detriment to the public good and that there's no substantial impairment of the zone plan and the zoning ordinance. While your board professional, Mr. Pettit, has a lengthy report, our engineer has assured us and has indicated through conversations that we are able to address the stormwater regulations. And as we all know, when it gets to site plan, there may be some modifications needed to address those stormwater modifications, but they can all be addressed on site so that there's not a negative impact to the surrounding community. In fact, when our engineer testified, he indicated that the stormwater basin would actually take some of the flow from the surrounding area, if I heard the testimony correctly. So it's actually adding a benefit to the community in that regard as well. With regards to the traffic, as Ms. Drum indicated, when a piece of land is vacant, any development is a change. Whether you look at it in terms of traffic or the fact that you're losing your vegetation or something is changing, it's a change, and there's going to be some impact, but is it substantial? The level of service A and the level of service C at the intersections is not something that is unable to be accommodated. In fact, the level of service A remaining at the intersections is a positive for the community. It shows that there is capacity for this development as proposed. We have to remember that this is a property that is zoned for development. In fact, your master plan specifically, which was re-examined in 2010, specifically talks about this property as being one of the significant pieces of undeveloped land left in the town. And it references that there are issues in your ordinance and things need to be rectified in your ordinance, but it definitely recognizes that townhouses and single-family development both are appropriate uses for this site, and recommended the zoning to include townhouses. So clearly there is development that will happen on this property, it's just a question of what. So we're trying to provide something for the borough that is consistent with the area and provides a needed amenity that you don't necessarily have. Your master plan does have several goals and objectives. They come from your 1992 master plan and are reaffirmed in the reexamination report. Those land use goals include promoting a balance among a variety of land uses that will support and improve the development character of the borough. They also include a housing goal to provide a wide variety of housing types to meet the current and future population at all socioeconomic levels. These goals and objectives, we believe, are advanced by the proposed development before you today. We believe that we're providing that variety of housing that is necessary and that variety of land use mix that is important for the borough. Again, you're very heavily weighted as you're about 70% single family detached housing. This creates that variety that would be appropriate in the borough. So for those reasons, we believe that there's no substantial impairment to your zoning ordinance or your zone plan as designed. We believe that the intent to permit a townhouse development is clear in the purposes of the R3 zone. We believe that there are some ambiguities in the ordinance and how it's set out in terms of what the design criteria should be. We believe that a rational development scheme, as we have proposed it, does make sense for this property. It's consistent with the surrounding character. It's a newer housing product that's not provided in the borough and therefore warrants the positive and the negative criteria under the municipal land use law, and that the benefits of granting this application would substantially outweigh the detriments. Again, recognizing, I know there's a feel for when things change, everyone feels that the detriments are going to be great, but you have to recognize that this site is zoned for development.
Mr. Cuddio, I just want to clarify a couple of things. You said we feel, I take it you mean I feel.
I feel, yes, I
The
like
collective I. Okay, fine. Now let me ask you a couple of questions. As a professional planner, based upon your review of all the documents that you discussed, based upon your review of the case law, based upon your knowledge in this field, and based upon your evaluation of this particular plan, do you have an opinion as to whether or not the positive criteria of 40.55D70D5 is satisfied?
Yes, I believe it is satisfied.
All right. Do you have an opinion as to whether or not there is any substantial, not any detriment, substantial detriment to the public good as a result of this proposed interpretation as the density?
I do not believe there is a substantial detriment to the public good.
And lastly, and you just testified, but I want to be clear, do you have an opinion as to what is it in regard to any substantial detriment to the intent and purpose of the zone plan and zoning ordinance?
I believe there is no substantial impairment to the zone plan and the zoning ordinance.
And in part because it is a permitted use in the zone.
Correct.
Okay. I want to take you through an exercise before we finish. I want to try to see what maybe the drafters of the ordinance may have been thinking. We can't know that, and the council isn't here.
Can you go closer to the mic again, please?
I'm sorry. I want to see what might be sensible. Ms. Cuviello, if we were to assume that the drafters intended to have 3 townhouse units on every 8,000 square foot lot, would you find that to be reasonable?
That would not be unreasonable. However, at a density of 3 units per acre, it would be unreasonable.
We're going to talk about that per acre. So if the intent was to make it 3 units per 8,000 square foot lot instead of 3 per acre, and you are entitled to have 3 8,000 square foot lots under the ordinance, or you really could have more, but that seems to be what's suggested, you would end up with 9 townhouse units per acre, correct?
I actually get 15, but
Anything over 6, I'm happy with. So you get 15? No, you get 15. Listen, I'm not asking you how many you could get if the ordinance was correct. I'm saying the ordinance is now written, suggests that you can have 3 units per acre. If in fact you could have 3 units per lot, and there could be 3 lots instead of units, you would have 9 units per acre.
Correct.
Okay. Would that seem to you to be a reasonable density?
9 units per acre is actually higher than some of the other densities, but still within the range of some of the surrounding communities and actually consistent with their area, so it's not unreasonable.
Now, were a court to look at this ordinance and try to determine what the density was intended, and they looked at 3 per 8,000 square foot lot, then what you were saying earlier, you would end up with 5 8,000 square foot lots per acre and 15 units per acre, correct?
Correct.
And we are proposing 6, which is 2/3 of the 9 and less than half of the 15.
Anyone else has any?
I'm good.
That is correct.
I follow.
It is correct.
Lawyer distorted.
Keep talking, Jeff.
Reasonable. Well, all I'm trying to prove is that what we're asking you to do is way below a reasonable interpretation of that ordinance. If somebody else were to look at it, you've already heard us tell you, and I mean this respectfully, it doesn't make any sense. And when you combine that with the Jackson Township case that says you can't require open space and you don't have a cluster, but you say it's a cluster, the ordinance is impossible to work with. It really is. That's not your fault. It's none of you wrote the ordinance. You're here to do something with it. Now, we asked for 2 things. We asked for an interpretation, and in the event that the board is not inclined to give us an interpretation that the density we're proposing is within the density, then we've asked for the D5 variance. If the board finds from our testimony that the only way this can make sense is that 6 units per acre is permissible, then that's it. Then if you vote in that regard, then we go to the next step, which is to bring our subdivision plan, our variances for setbacks, etc. If you find that it isn't, then we need to ask you to consider the density variance, which we put on the table. So those are the 2 options that we have requested of the board, and the board, I believe, and you'll have to, of course, listen to Mr. Rowan, but I believe you could exercise either one of those in this application.
Mr. Barron, can I ask a question?
Yes.
I think this is where Mr. Dickinson is going. He raised an issue in our letter about what the tract size is.
Mhm.
You start out, I believe it was 18.22.
Correct.
There was a portion of Lot 2, which was, there was a minor subdivision, which was then going to be attached to this parcel. Plans also show a portion of the parcel which will then be consolidated with Lot 6. Do you know, once those tracts are changed around, what the overall tract area will be? And what does that do to the density?
The 18.2, the 18.3 is the actual tract area provided by the surveyor. So that does not include any exclusion of the lot to be developed at a later date.
That includes all of the green. 18.2 includes all of the green?
Before you say anything, I've pre-marked that exhibit, Exhibit A-2. So what you're now looking at and testifying in regard to is A2.
Okay. There's a set side lot of 13,000 square feet plus, which is about a third of an acre, that to be dedicated or given to lot 6 under a separate application. That would make the total lot area in this application around 18 acres, not 18.3. And that will resolve that
Portion of
discrepancy.
Lot 2, which is being consolidated with this.
So that, I'm sorry to repeat that.
There was a minor subdivision application for the board earlier this year, where you took Lot 2 and took the rear portion of it to be consolidated with this tract. So you have a portion of Lot 2 which is being consolidated, and a portion of the tract which is then going to be given a Lot 6.
Was that shown on this plan?
Yeah, you're showing the 13,752.
Yes, yes.
To be consolidated with lot 6, but I don't believe you include the portion of Lot 2, which was subdivided previously, to be joined with this parcel. So I'm just trying to figure out, once those two acts occur, what the balance is.
I'm not aware of anything related to lot 2.
Mr. Pettit, we understand. I know that there's a member that's not present, so I'd like to make that member. Madam Chair, I'm
Yes,
sorry,
sir.
I see that one of your members has stepped out. I prefer if we would admit.
I think we should probably take a quick break, and so I was waiting for the secretary to come back in to instruct her to have a brief recess, so everyone, they can go use the facilities or step outside for a moment while you all...
Can I just ask that everyone can agree with this, that the record should reflect that there's been no presentation of testimony nor any comments from the board during the period that
Ms. Gushin stepped out.
Gushin, I didn't know how to pronounce it, stepped out.
Yes, sir. So what we're going to do is we're going to get maybe a 5-minute recess. They need to step out, leave the facility. We're back in about 5 minutes, okay? Get us back into session. It's almost 9 o'clock. Everybody can just be seated, please, and we'll resume our meeting.
Thank you, Madam Chair.
And just one more housekeeping matter. I think we would have been remiss to not state that Mr. Ober will be voting tonight. He is an alternate, but in the absence of Mr. Fullerton, who is not the councilmatic seat, and he is not the mayor, he would give us our full quorum.
He could sit up for Mr. Fulton, but.
Correct, Mr. Fullerton. Correct. You can sit for Mr. Fullerton. Correct. So he will be voting this evening. I'm sorry we didn't announce that earlier.
Thank you, and thank the chair and the board for making sure that there were 7 members. I spoke to June, well, I didn't speak to June, I keep saying that. My secretary, Shelley, who has become very fond of June, because she's very informative, told me that as far as you knew, you'd have 7, and we appreciate that. During the break, we wanted to address Mr. Pettit's question, which is a very good question, as to what the real track size is. So if I might, I'll have Ms. Cuviella show you the area that was in question, and depending on whether it is in or out, what the difference is in the density.
Okay, so I'm going to actually take that out, because if I try to point and describe.
You're referring to A2?
I'm referring to Exhibit A2, and this is a colored rendering of the site plan application. So what Mr. Pettit was referring to is this L shape, and that's the Hartford Drive area and Evesham Road. It's one of the Evesham Road frontages. This area is 13,752 square feet. Our plan shows that this L would be subdivided off and combined with Lot 6. Lot 6, I'm going back to A1.
Good job. You can be a lawyer now.
Is what appears to be a vacant piece of property, correct? It's vacant. It's a vacant lot. And it's at the signalized intersection here. I'm going to go back to A1 now. Or A2 from A1.
They're fine.
I'm going back to the big plan. So with this piece in, we have 18.3 acres. I thought it was 18.2, which is where my 6.25 came from. But it's actually 18.3. Our density at, I didn't do that calculation, but our density is around 6.25, which is, when you round it, 6.3. If we take this 13,752 square feet off and add it to Lot 6, our total lot area goes down to 17.9 acres and a bunch of change. And the density with the 114 units becomes 6.34. So we're still pretty close, and we have the option of doing one of two things. We can either continue to give this to Lot 6, which from a planning perspective, I think makes good planning sense, because this property While it's zoned residential, is at a signalized intersection, any development on this property, whether it be something that doesn't conform to the zone but conforms with the surrounding area or is residential, would be benefited by a driveway access on Hartford and not on Evesham, and this subdivision consolidation allows that to happen. The impact to this development is a tenth of a unit per acre, so 6.25 to 6.34. I think that the benefits of going with the calculation that your engineer pointed out would be better, even though we represented 6.25 after discussing it.
Let's, Ms. Caviello, let's just be clear. So what we would propose as, in your opinion, better planning is to consolidate the flag lot, for lack of a better word, with the existing rectangular lot to create one new lot at the corner, correct? But I will tell the board that if for any reason you feel inclined to determine that a variance is needed, that we would agree to leave it as open space to get to the original calculation if that's what the board would propose. We believe this irregular shape isn't very valuable as open space. You can't do anything with it. So it makes more sense to make it part of the other lot.
And that makes that lot almost 30,000 square feet, which is a good sized lot for development.
Madam Chair, the only other thing that I have is I would like to move exhibits A1 and A2 into evidence before the board this evening. And I would, thank you, Mr. Rowan, and I would like to reserve the opportunity to address the board at the end of the public portion to address any questions that might be raised by the public, please.
Sure, thank you so much, Mr. Barron. Does the board have any objection to us maybe turning the easel around so it's just for the edification of the public that they can get a chance to look at it? We have to set up here. Yeah, would you see that for me? Okay. Everyone can see that okay? I think what we'll do first is we'll defer to our professionals for their comments. Mr. Pettit is our engineer.
Yes, Madam Chairperson, members of the board, we did submit a letter dated September 25th. They've asked, pretty much all of the letter deals with the actual subdivision design and roadway profiles, drainage, as Mr. Fanous had indicated. We have several comments on the drainage. We have gone through those together, and I believe that, he will, should the application move forward, that our offices will be able to work those out. If it gets to the point where they can't meet the stormwater design standards, then they don't have a project. That's the case with any kind of development coming before the board. We did look at the traffic impact report that Ms. Drum submitted, as she indicated, the levels of service in A and C, which in industry standards are acceptable. The number of additional trips in the morning are 60 in the peak hour and 70 in the peak hour in the afternoon. So it's up to the board to determine if that's a substantial impact on the existing roadway system.
How would a school bus or 2 or 3 or 4 affect that?
I'm sorry?
How would a school bus or 2 or 3 or 4 school buses, which I'm anticipating are going to be going into this project, how would that affect the traffic counts?
I don't know. Could ask Ms. Drum if she included.
Absolutely. She's our expert.
You heard the question from the chair, would you find out the answer, please?
One, the data collection, probably some of the empirical data that is collected, if school buses did go into a development, that would be considered. I can't tell you if it was 1 bus or 3 buses. But if it's additional 2, 3 buses, I don't see that's going to be an additional significant impact. The only thing you want to be worried more from a site plan perspective is if a bus is actually going through the development, that the turning maneuvers are appropriate.
Right. And that would be a thing for the plan. We would look to that once we do the plan.
Correct.
And I wouldn't like her to say, not I wouldn't like her to say. I want to find out what she would say, and then I'll see if I should ask her the question.
Hopefully.
answered what you've asked us, so I don't need to ask anything.
Okay, thank you, Ian. Appreciate it. Go ahead, John.
The only other comment I have that has to do with the density itself, has been testified, and as you read in the ordinance, the R3 zoning district is provide medium density residential areas on the R1 residential zone, and I think it's up to the board to make a determination whether the density which is being proposed, which is now 6.34, 3 units to the acres permitted, would rise to the level of being high density as compared to medium density, and whether or not you believe that's going to have a substantial detrimental impact on the surrounding areas. And I believe that's up to the board to make that decision.
Okay, Mr. Rowan?
Mr. Chairman, members of the board, the case law that Jeff cited is correct. The Jackson case does state that we cannot mandate open space. We cannot make that a condition of approval. He cited the Coventry case, which I believe, I agree, was a Supreme Court case dealing with square foot floor plan. Is that correct?
It was a project that was, in essence, apartment and combined, and yes, they needed variance from the floor
Floor
area
space.
ratio.
And those standards which the Supreme Court set, the relaxed standards to prove such variances, was adopted by another case, Grubb versus Slothower, which specifically dealt with density cases. So the court in density recognized the relaxed standards set forth in Coventry and incorporated them within density standards, which the applicant, through their testimony, has addressed. Which, if the board is satisfied that this lot can accommodate the requirements of the density required, then the board has to give that deference, has to consider that. In addition to that, another proof that has to be offered by the applicant, which the applicant did address, is the negative criteria. You heard the testimony of Tiffany, I believe, that to address the negative and positive criteria, and she is correct. There has to be a substantial detriment. In other words, you have to not believe her or believe, regardless of what the applicant said, there is a substantial detriment in granting such a variance. If there's not a substantial detriment, then the may have to look to approve such an application. But once again, you're the final arbiter of whether you would consider that there is substantial detriment. If you find substantial detriment, that should be placed on the record. And when you vote, and your reasoning for that, why you would consider substantial detriment. The requirements to, the proofs that are needed have been offered tonight. Whether you accept those proofs, that's up to the board. But under the case law cited, the applicant has addressed the applicable law and the applicable proofs, and now you have to make a determination. You can also consider, which I know you're about to do, is to open this to the public for their comments and concerns. And those comments have to be given consideration too in making a final determination.
Thank you, Mr. Rowan. I guess what I wanted to address with the applicant, as we all know, a townhouse is a permitted use. There's no question there. Also no question that Mr. Butler has a right to develop this property. That's what he's here for. That's why the property is there, to be developed. Having said that, I have been probably on this board for about 15 years, and this is a very important application to all of us. We take this very seriously. We come up here and we try to put forth our time and effort to try to make something that's fair and equitable, not only to the applicant, but to the town itself. And I would hope that, as we don't want to draw a line in the sand, that's not going to help anyone, I would hope that perhaps the applicant would entertain giving some consideration to something with less density. we have our ordinance, that's what we have to work with. We didn't, like you said, we didn't write it, that's what we have to work with. I know what your case law states, and I know we cannot compel you by law to give any open space per se. But I can say that we worked very diligently when we developed our master plan. We were here for hours and hours, and we have a vision for this town. And our vision is just a little bit less density than what you guys are proposing. We have a medium density on our ordinance. It is my opinion that this goes to a high density. I would like to know if the applicant would entertain anything so far as a reduction in the density on their application.
Madam Chair, it's always the answer. If I know what you're asking, I can say yes or no.
Okay.
When you say a reduction, there's a whole lot of reduction. I mean, you might tell me 114 is too much, how about 1? Or you might tell me 114 is too much, how about 110? So if I know what the board is thinking, then I'm happy to talk to my client about it while the public testifies.
Well, and then this is just me, I'm only one person. I'm one person here, and
We acknowledge you're only one person.
I guess what I would like to see is something in between. Something in between the density that we have in our ordinance and something between the density that you're proposing, a halfway point. Meet us halfway, try to make it a little more palatable for us to accept as the zoning board as far as our vision for the town was concerned. Of course, we have concerns about the traffic. Everyone in this room has concerns about the traffic because we live here, and I know we have traffic studies. I know we have all these things in paper, but I know the reality of it is that if you add the proposed 2.5 cars per unit, that's a lot of cars that you're going to put into the traffic pattern. Whether they're all the time or half the time, who's to say? But I think, like I said, you're right in developing the land. That's fine, but that's not what we had in mind when we did the master plan. And we really liked the plan you guys put forth last time you were here. And I understand if it's not something that's economically developable at this point in time, we're not up here to dictate to you to build something that you can't sell. It doesn't make any sense either. But if you guys would, and I'll defer to the rest of the board members to comment on my comments, but I think it would be more palatable for everyone involved if we could find some medium ground to, I guess, come to a middle spot where it's not quite so high, and to help you, it's not quite so medium, and maybe we could set forth and get this ball rolling.
Having done this for 40 years, I'm not surprised. Having consulted with my client before the meeting, no, I'm sorry, we can't do that. We can't meet you in the middle. As much as we would like to and avoid all the controversy, we feel very strong in our case, we truly do. We think densities could be permitted at a much higher number, and that we've already decreased it. Would we do something? Yes. Would we split it? No.
Would you consider 5 units per acre?
We would consider 5 units per acre.
That would be a reduction down to approximately 9.
I don't want to say that that's.
No, I'm talking.
I want you to say we will definitely consider it, and I'll have to talk to Mike. It is an economic issue.
Sure.
What that 5 units per acre is going to ultimately yield to us, but I think that message, you've heard testimony. You will either accept it or not. That's part of your function as a board. You've heard Ms. Cuviello tell you it's 5 acres in the single-family 5 per acre in the single-family residential in that area. So if we agree to that, we're agreeing to a much lower density than townhouses normally considered. But even though it's on one track, as opposed to the single-family that's spread out, it's the same density. So if we were to go there, it's totally consistent. I mean, I don't know how anybody could argue that, frankly. But I will talk to my client about it, Madam Chair, and I appreciate your giving me the opportunity.
Certainly. Does anyone else have any, not the public yet, anyone else on the board have any comments or questions?
No. I think it's a good proposal.
Okay, at this time, I would like to open the meeting to the public. Anyone wishing to speak on this matter and this matter only, come forward, be heard, and state your name and address for the record, please.
Good evening, I'm Charles Buckheim. I live at 223 Sunnybrook Road here in Runnemede. I appreciate all the information that we've gotten this evening. I'd like to make my comments based on the experts that have been up here. I'm an expert as well. I would say first I'm an expert as a resident of Runnemede. Contrary to the highway study that was done, I have lived in this community since 1964. That's 49 years. I've been a homeowner in this community for 38 years. I live back off of Davis Road on Sunnybrook Road. I've been retired for 7 years. Prior to retirement, I left my house in the morning at about 20 after 5 to get to the office, and I would get home about 5:30 in the evening. So I didn't get to see much of the traffic flow off of Davis. But I've been retired for 7 years now, and the traffic flow on Davis between approximately 6 a.m. and 8:30 in the morning, and 4 in the afternoon and 6:30 in the evening, probably without exaggeration, triples or quadruples. We have a lot of young children that are waiting for school buses in the morning and getting off school buses in the evening. Now, if I use the mathematics that these experts have given you this evening, they said that of 114 units would average 2.5 vehicles. That's only for the people living in those homes. People do visit other people. The number of vehicles that would be in that development would increase after work hours, weekends, and holidays. But if we just take the 114 units times 2.5 cars, and my basic math I think is pretty good, that's 285 cars. So I don't understand how they're saying the traffic increase in the morning would be 60 vehicles, and in the evening it would be another 70. It's 285 cars. That's a lot of additional traffic. Living back off of Davis Road also, you have a lot of people that are traveling from Gloucester County in the Deptford Township area that work in Cherry Hill, Pensauken, Haddonfield, and those areas. In an effort to not get caught up in traffic on Evesham or Clemens Bridge Road, they cut back through Davis Avenue and go out onto Atlantic. Being retired, I have the opportunity 3 days a week to go to LA Fitness over in Stratford. I am at the gym at 6 in the morning. And at 6 o'clock in the morning, I have to wait to pull out on my street on Sunnybrook Road on the Davis because of the traffic. I come out of the gym at about 7:30, quarter of 8. And as I'm coming up Evesham Road back to where I live, the traffic going in the opposite direction towards the Whitehurst Pike, and this is at about 8:15, 8:30 in the morning, is backed up at least a quarter mile past Atlantic Avenue trying to get to the Whitehurst Pike. That's what it's like now. Imagine what it will be like when we have 114 additional homes, 285 additional vehicles, and even more when people are visiting in that development. And where do they park, the people that are visiting? If you've got only one car garages, one car in the driveway, and the rest have to park on one side of the street, that's a lot of congestion. So that's my point about the traffic. Let's talk about how it's going to impact something that they haven't mentioned, the school system. I'm also an expert in education. I am certified in the state of New Jersey as a teacher, department supervisor, director of instruction, principal, and superintendent. In my 34-year career, I served in every one of those positions except the superintendent. So I know how population increase impacts school systems. I'm also currently sitting on the Board of Education here in Runnemede. 2 of our 3 buildings were built in the 1920s, one in 1922, one in 1928. The square foot requirement for a child in a classroom in 1920s is not the same as it is in 2013. If we build 114 units, you're going to, and I would imagine, I'll use a low number, we're looking at probably 1.5 children per household, and I would believe that Mr. Butler, who wants to build this development, if he's hired an attorney, I'm sure they've discussed the kind of impact it's going to have on the population in our school system. Our school system is almost at capacity now. There's no way you can expand Bingham and Downey. I don't know how we could accommodate the children that would be coming in to this development of 114 homes. unless possibly the builder would like to make a significant contribution towards our school systems to help build a new school. I think those are my major concerns, and I'm not against Runnemede having a restaurant with a drive-in window or having some townhouses in our community, but I think we need to take a look at the number, as was stated by the chairman on the board, how it's going to impact our community in many ways, as traffic flow, our school system, and just about any other aspect you can think of, trash collection, and go on and on and on. I hope and I pray that this board will also maybe take a look at our current ordinance, and maybe we just need to revise that ordinance before we go any further. Again, I'm a proud resident of this community for 50 years. It's a great community to live in, but I think this development would have a negative impact on our town. Thank you.
Thanks, John.
My name is Ron Cavallero. I live at 281 Evergreen Road. I want to point out here with the map, these experts all gave you all the density of the houses in this area. I live back here, and here the density requirements is 1 dwelling per acre, or 1 per half acre. And there's 3 streets that are in line here that have those same requirements. And Charlie covered the school issue that I wanted to discuss. As far as the traffic, we all know what the FedEx did in Barrington, and the traffic analysis was grossly underestimated with that. The other impact would be the traffic, just on Isham and Hartford. And there was something else I wanted to say. But anyway, the impact on the taxes. Oh, the developer wants to go from, I believe he had applied for 55 and
54 single family.
okay, and now they're unsellable at this point because of the economy. You're all aware of how many houses are already for sale in Runnemede that aren't selling. So what are they doing here by increasing it? Instead of making their money with quality, they're going to make it up in quantity. And eventually this will end up being low-income housing if they just sell half of it. And I don't think you can afford that. I think we have enough low-income housing with the apartments alone. And that impact alone on our taxes. Because we're all in the same boat in Runnemede. It is a blue-collar town. Thank you.
Thank you, Don.
I'll follow my husband, Barbara Caballero, 281 Evergreen Road. I have a question for when they did the traffic survey. They did it in August, and they did it in November. We need to check the date of the November one, and they did not do it after school. There's so many days the children are off that that may not be an accurate count even then.
I can give you the date.
And the other thing I'd like to say to the board, we need to consider talking about the schools and all. If this is the only tract of land that's vacant, we have 2 buildings that are all but obsolete. Maybe we need to think about some other uses for this land. That's all.
My name's Barbara Warburton. I live at 297 Evergreen Road. And I have a question about the traffic. Are you or are you not required to do a traffic study
the very next street, Schubert and Evesham, which is where the high school is. And you said during your conversation, if there are buses that do happen to go to the apartments, I know for a fact that there are several special ed buses that go there every day. And my other question that I was told to address to the lawyer was, are you required to send notices to the people that live near this development? Because I'm right behind the water tower, and so is my next door neighbor. And nobody on Evergreen has gotten anything.
I'd be happy to, but can I ask you a question? You said you were asked to ask me? Who asked you to ask me
Well, I was
that?
told it was your responsibility.
Oh, okay. Well, let me tell you what I believe, and then Mr. Rowan can say if I'm correct or not.
Okay.
On every application, an application for development in the state of New Jersey, you're required to obtain a certified property list from the borough, in this case the borough, the municipality. That certified property list is done by a municipal employee. The law requires that we notice anyone within 200 feet of the outbounds of the property. So only, oh my God, we're walking into the lake. Anyone within 200 feet of this outbounds hopefully is on that list. That's all we're required to do.
So because of the water tower,
We're required to do 200 feet throughout, but we are entitled to rely upon what we get in that list. And if we notice all those folks, that's all we have to do. We don't do it. We don't go out and measure. It has to be done by the municipality so that you can rely upon it. That was done. We provided an affidavit that everyone on that list was noticed, and I did the noticing by certified mail. So I can tell you we fully comply with the laws to notice.
so if there's something like a water tower, then that relieves you of any responsibility to
No, we notify.
human beings that are living that right behind that.
That's correct. We notify the utilities,
That's correct.
but we're not required to notify any individual.
Hey, Barbara, that's done by our tax map, just so you know, that the notification is done by Runnemede's tax map, not by Mr. Barron's map. It's done by Runnemede's tax map. And Mr. Rockley, you had a question?
Yes, what was the date of the November traffic study?
Yeah?
The written report was dated November 18, 2013.
When was it done?
So what day of the week, and was it during school?
It was during school, they were done on November 14th and I believe 13th.
14th, Wednesday and Thursday.
And the reason we did that was, if I'm right, and I'm not testifying, I'm just commenting on why I submitted it. The original one was done in the summer. And there were concerns, I think, that that did not.
I requested you do another one, and you complied, and I appreciate that very much.
14th to 15th. Wednesday,
Yes, sir.
13th and 14th.
Hey, Tristan Morales, 301 Evergreen Road.
Christian?
Tristan with a T. Again, can we get a copy of that notification of who was supposed to be notified? Because again, I am literally right behind where this is being built. I'm sorry?
It's 200 feet, you're more than 200 feet. The water tower alone, that property.
That's correct.
So what you're saying is the other town doesn't give a shit, right?
That's terrible.
Oh, could you have a copy? We have no problem with you asking Mr. Pinto for.
Again, if I wasn't supposed to be notified, I don't see if there's a
We're not
purpose in
trying to-
having it. Again, it's just, I mean, literally, I know people in the development in Barrington that were notified, and they're farther away than I am. This is backing up to my property.
We're
So-
required to notice adjoining communities that are also within that parameter, and we did. In fact, again, June can confirm this. The first time we did it, we didn't give every municipality notice. We recognized we made a mistake. We went back, we got every municipality and we were noticed. That's right. And I was just gonna say, if I might, I've been in front of a lot of courts, and when a gentleman gets up and says, I didn't get notice, the judge says, well, you were there, weren't you?
I've heard from other people after the fact. This has already obviously been going on for a long time. I would have been here a long time ago, as well as a lot of my other neighbors to discuss the situation if we had been notified at the beginning, not yesterday.
Yeah, everyone within 200 feet was notified. We have proof of that. We have the green cards.
And again, I know they were talking about the density, and the young lady that came up here and was shooting out numbers said that in the area we had anywhere from 2.25 to 7.25 per acre. She said that 6.4 was in the middle. My math seems a little bit off. That doesn't sound anywhere near the middle of 2 and 7 as to what we're saying Runnemede already had. And again, then another young lady came up and discussed as well. She said, lady in the black shirt, I apologize, I don't remember people's names, but she was talking, Tiffany, was talking about how she took into consideration the traffic report when she was talking about whether or not this would be feasible, whether it would work or not. Was that both traffic reports or just the initial? Both traffic reports were taken into consideration. And again, why is it just the 2 rows, Evesham and Hartford? Again, we didn't take into consideration the traffic. I mean, I had to go to 295 every morning going in front of FedEx. There's a cop out there because traffic is so bad. I mean, I sit there for 20, 25 minutes every morning. There's no way that this isn't going to have a negative impact on that. This is not to mention the fact that, well, what are we doing with property values here? I literally just bought my house a year ago, which they're saying houses aren't selling, but I just bought mine a year ago, as well as my neighbor across the street from me. So homes are selling, but that's not our problem. If the houses aren't selling, it doesn't mean that we have to suffer with property values because they can't sell a single-family home, so they're going to put these, again, low-income houses in here.
Well, unless you have an appraisal of what you'd be getting for your house if you sold it, we really can't take that into consideration.
No, I understand. It's just, again, I don't think anyone's taking property values into consideration at this point.
Well, you made, I just wanted to respond to your statement, that's all.
Thank you.
You're welcome.
My name is Tricia Martell. I live at 402 Sheffield Court, and that street should have significance because the way the current plan is laid out, the only entrance and exit for this plan will be directly across from my street. My street is also one way in, one way out. There will be no way for us to escape that traffic. As it stands right now, it is very challenging to get out of our street every morning, off of Sheffield onto Hartford, whether you're turning right or left. Putting the stop sign in slightly down the road from us, across from the apartments, did improve it somewhat, but there's still a tremendous amount of traffic that rolls through that stop every morning. Creating a situation where you are going to have a substantial traffic flow coming directly at us is going to make that 2 to 5 minute wait in the morning to turn unimaginable. And to have to leave my house an hour early just so I can get out of my own street is ridiculous. If that's not an example of an extreme hardship for the 17 houses on my block, I don't know what is. Thank you.
You're welcome. Thank you.
Amy Perry, 816 North Reed. I just want to bring a couple pieces of fact that I think you guys should take into consideration. I used to be on the school board, and I actually am going back on in January again. So anyway, thank you. What I wanted to say is there's some things that have happened over the last couple courses of years that we had to eliminate from our budget. One was busing. And busing, we had originally had busing to a greater, larger area. They deemed it not necessary. So that was $200,000 in our budget. It was in this vicinity. That was for a small group of kids. Now, here's what we need to take in consideration. Chai spoke of the maximum number of children. We could put 30 kids in a classroom, if that's what you want. Do you know what I mean? Like, there are choices that we can have. We can rent trailers. We can put them in sheds. We could do whatever is necessary. But here's the thing. I know that if I want to sell my home, or you want to sell your home, we have to have a good school system, because that's what sells homes, right? And we all take great pride in it. So I can't very well say, please come buy my home, if I have 30 kids that are in a trailer as our option. So let's fast forward, and all the kids come here. And let's just say there's 114 homes, and if there's only, I don't know, what is the actual calculation that we're allowed? Do you know? Is it 1.5 children per home? Is it 2 children? I'm not quite sure.
We will give testimony to the question, and it is 0.43. It's less than half a child.
Less than half a child. Well, I've got 3. I don't know how it's half, so I carried twins, and they didn't feel like half to me.
It's America.
So anyway, if it's 0.43, let's just go with 1. right now, if there's 22 children, give or take, in Downey per class, that means that, and we only took it to 25. That means that we could fit 24 children in Downing today. Now, here's the flip. Do we have to bus them?
Yes.
We do. Okay, so if we can only fit 24 children in Downey next year, right, based off of the numbers, and we put 24 kids in there, we now have to get them there. Now, do they go to Volts, some of them, or do they all go to Downey? Because there's only 24. So if 24 go to Volts, that's fine. I mean, Downing, that's fine. If we got to go to Volts, it's more. So we eliminated $200,000 out of our budget. So now we're over $200,000 more back into our budget. Where I'm going with this is even if we didn't build a new school to house the children, we're still going to have to get them there financially. So who's going to foot the bill? Every resident in Runnemede, whether you live within 200 feet, whether you drive down Isham, whether you drive down Davis, every resident in the 3,400 homes that are in Runnemede, based off of your number, are going to foot the bill to take care of the children that will move to the development that then someone else benefited from financially. And I understand that we all have that right to fortify that, and we all want to make an income, and I get that. But instead of freeing space, because he doesn't have to do that legally, according to what they're saying the Supreme Court said, why don't they build us a school there? Because technically, if there were 2 kids per house right now in Downey, there's approximately 175 children today. Don't hold me to the number. But what I'm saying is, if there's going to be roughly 175 kids, they constitute their own school, according to our numbers where we're at, because there's nowhere else to put them. So I really please beg of you to consider the impact that it'll have on every one of us and our taxes, because that will drastically affect everyone in our town. Thanks.
Thank you.
Madam Chair, board members, my name is John Massanova. I live at 541 Drexel Court. I've been a resident of town for 33 years. I have some experience with development and engineering and studies. You're right, Mr. Butler does have a right to develop this property. He's a developer. But as a developer, everybody knows who buys it in, there's a chance that it might not be developed, where there's other rules and regulations, or as the solicitor said, boards that can object to what is going on. His solicitor attorney mentioned about the plan that we should have. Well, this town, with the amount of apartment buildings that we have and all the other houses that are built on 40-foot lots, we have an overcrowded. And it's not that it's not the value of the houses that's going down and they're not selling. People just can't get mortgages. The economy's bad. And they're not going to make any difference whether they go at these townhouses or individual houses. With this project right now, with 114 people, what we're dumping onto the schools, not only the police, because that all has to be patrolled. You have Hartford Arms back there, or actually it's Meadows, I'm sorry. It was originally Hartford Arms, and for those of you that sat here on boards, as I did years ago, knew the problems we have with Hartford Arms. We got presidential. That whole area is so dense that dumping more homes in that area with the amount of traffic that comes out of Isham Avenue and Davis, Schubert, it's going to be astronomical. As the young lady said about the schools right there, that school's frightening. And the amount of children that go there from Runnemede compared to what we put into our elementary schools there's no, that school could not really be taken into account. So, your solicitor did tell you, the board does not have to rule in favor. And as the solicitor told them, there's other avenues. But as a board, you're responsible to do as best as you can. Okay? Not compromising. I'd much rather fight in court, not put a development up that's going to be detrimental to the community, and then paying for paving some of the roads that haven't been done anyway. So, as a board, you have to take all this into consideration. Police, schools, traffic, cars, 200 cars, 300 cars in that area alone is not the problem. And as a developer myself, and as a person who's been studied engineering, had engineering plans done, you can make any number work anytime you want. Okay, when we built this property right here, we had an engineering study done. It's just a matter of what time of day it takes. Okay? And the same thing happened back with Federal Express. And when you take a planner, that's her job. She's there to tell you what we can do. You have an engineer there that, works for us. So, I just ask you to do the right thing, and, other than that, it's up to you guys.
Thanks, John.
I'm Henry Ryder from Florida Sheffield Court. I'd like to ask Ms. Drum again about the time she did this traffic study. It sounded like she did it at 9 o'clock and 4 o'clock. And why did she consider only the major highways like Evesham and Hartford, and also Davis and Hartford? There's other streets involved in there.
Yes.
Which is that if she started her study at 9 o'clock, well, that's way past the rush hour in the morning. And if she done it at 4 o'clock, that's in the middle of rush hour in the evening. But as FedEx opened up, there's more trucks coming down that Hartford Drive, and it's really difficult to get out of my street, because it is a cul-de-sac. There's only one way in and one way out. The consideration of the other streets that feed into Hartford Drive, like from the apartments, and also Sharon. There's more traffic that goes through there.
Mr. Barron, I don't want to speak for the traffic report, but my notes have that Ms. Drum stated that the manual counts were done for 2 hours, 7 to 9 a.m. and 4 to 6 p.m. Is that correct?
7 and 9?
I want to review her testimony again to answer your question.
Yes, that is correct.
You stated that you thought she started them at 9. No, she started them at 7 and went from 7 to 9, not starting them at 9.
But there's other people that in their rush hour, they start like about 5 o'clock in the morning.
Sure. No, I was just trying to correct what you I wanted to make sure you understood her testimony to be accurate, that's all. You're welcome. Sure.
My name is Joan D. Peterson. I live at 310 Evergreen Road. I've been there 53 years. I've been in town 79 years, so I remember when the Blackbirds Pike was not macadam, it was dirt, because I was born and raised on First Avenue. And I'm going to tell you, the Hartford Arms was a very large detriment to our living where we are living now. They came through the woods and robbed us blind. And there's people in here that can state that they were robbed as soon as those people moved in. They came through with guns. 2 men tried to get in my house. One of them ripped the doorknob off. The following week I got a permit and got a 38. Because I decided that was necessary to live in. And that's a sad statement. Because the cops do know I would use it. And I've had the police back there, I don't know how many times, simply because of the fact of the people coming through the woods, stealing everything they could get their hands on. Now, how close is this going to be to the line where the water company starts? There's a stream there. There were wetlands back in there, quite a few wetlands, which were bulldozed over, which should have never happened. I'm quite involved with Fish and Game and have been for 53 years. And those wetlands should have not been ever bulldozed over. Now, that's against the law in the state, but they were. Are they going to bulldoze the stream that's there?
The engineer can testify to that, ma'am.
I would like to know the answer. Also, was a piece of property bought that will take a road out onto Davis Road? Nothing on the Okay, because I was told that a gentleman had sold a piece of land there that will go through and come out on the Davis Road.
No, it was not, and I would just ask you to consider the testimony tonight that Davis is the worst road to put traffic on. The
Davis is
gentleman-
very bad.
The gentleman who's
I
on
know
the
that,
school
I'm
board
on
said,
Evergreen.
yeah, the gentleman on the school board said he lives in that area, making an access to Davis as opposed to where it's proposed.
Well, I
will not.
come right out on it, I'm on Evergreen, that's
Okay.
the first street.
Okay, I just
So I
wanted,
know exactly how bad it is.
thank you.
And I do think the density of this is ridiculous, but of course, I don't have a nickel in it. That's what it's all about, them making more money by putting more properties on their piece of ground.
Absolutely.
And that piece of ground, as soon as it is filled up, where are all those people gonna end up and where are they gonna go? Are we gonna have more visitors? Because I was told that over on Sunset, they had people come through from the Beaver Drive over there and looking in windows at 4 o'clock in the morning. So it is a problem back there. We've had to fence the whole property and we have locked gates 24/7. And I don't like living like that because I've been in that house 53 years. And that's not a great way to have to live, to be looking out your window and wonder who's looking in. So I just hope that you guys can consider it. I know that you're right up against a brick wall. You absolutely are. But there's not going to be any open space. We've got something like 60 turkeys now, which nobody cares about. We've got about 15 deer, which nobody cares about. And where are they going to go? I mean, I'm in wildlife. Are they going to call me to ask me to come put a leash on the deer and take it out of their yard? It's not going to fly. So that's another consideration. There should be some open ground there, if nothing else. And also, is it going to be like the Hartford Arms and run storage into the stream, which at one time was clear and had fish in it? Because that's what they were doing in the beginning.
Again, I think Mr. Tanos, young lady had two questions for you. Ms. Peterson asked about the,
Did you say Mr. Samos?
no, his name is Tamos, T-A-M-O-U-S. I'm change your last name.
Hey, and I've had a good fight back on that piece of ground.
If you read the Courier today.
I have it right in my pocketbook. Anybody wants to read it? I have a scrapbook on Mr. Samos. And
We want to address your two questions, Joe.
If you look at the plan, we do have a dash line. This different color green, that's wetland. This dash line here, that is a 50-foot buffer required for that wetland.
Okay.
Any disturbance to any environmentally sensitive areas on site, that would be subject to DEP approval, and that would be one of the conditions of the board.
And these are going to be nice people that won't come out their back door like they do over now at the Metropolitan and shoot their guns from 10 o'clock until midnight. Oh, that's okay, we're even. Don't worry about it. They come on the property, they've got a problem.
Thank you, Joe. Is there anyone else in the public who can
Again, it's Christopher Elson, 301 Evergreen. Young lady did report from 4 to 6 o'clock. My children get bused home at 3 o'clock in the afternoon, and I have to be personally home from work at 3 o'clock in the afternoon to make sure I'm there for my children. I know other people in the area are as well. So, again, that's another piece of traffic that wasn't considered at that time. Thank you.
All right, Tricia, thanks.
Dan Massanova, 521 Drexel Court, Runnemede. In regards to the traffic, I forget what word you were using, the traffic analysis, how many hours total was that? So you had 2 days, you did it for 2 hours in the morning, 2 hours in the afternoon. So a total of 4 hours over 2 days, that's 8 hours. There's close to 9,000 hours the entire year, and they choose only 4 hours to quantify an estimate of the traffic in this town. How do you consider yourself an expert saying that you only quantify 8 hours? I didn't do that good at math, but those numbers don't add up. Secondly, we have a lot of wild game in this town. I, for a fact, know that there is a very large number of deer that live in that tract of land as well as on 9th Ave. going down there, going to Home Depot as I do for what I do for a living, I almost hit 2 fawns and a mother just the other day. What happens to those animals? Just become roadkill? I understand it's not that big of a deal in the grand scheme of things for the town. It's something to consider. The other thing is, I lost my train of thought, I apologize. You know, and I lost it. Hold on.
Sounds like the debates for the Republican Center.
I mean, it's
Like,
just-
yeah,
This was originally drawn up for how many homes? How many single?
54.
All right. Now, if this is what they're proposing, why isn't it being brought as a whole new plan as opposed to a variance?
It is a whole new plan. It's a density variance, it's required, and I'll let Mr. Rowan speak to it in detail, but basically, it is a new
Just
plan.
seeking a density variance, it has nothing to do with they have to come back in then for the subdivision.
Okay.
They have to
I'm
come back
coming in late in the game. I only found out about this
Yeah,
meeting
this is
yesterday.
just the density aspect. This is if, a lot of towns have 2 boards, they have a zoning board and a.
I'm familiar with it.
So technically, if there was a 2-board township, Jeff would have come in first to the zoning board to get his density, to say, well, how many lots can I, how many units can I possibly get on this site?
Mhm.
And then he takes that and he goes to the planning board.
I'm coming
So
in
this
late in the
was
game
just-
in
This
this,
was
so.
just for the density.
Okay, so nothing's been approved yet, not even the homes? Not even single-family homes?
The homes were
There was a
approved,
previous approval
yes,
They were approved?
yes, sir.
last year.
Preliminary.
A year and a half
Okay,
ago.
so now this is a completely different plan.
Yes, sir.
All right, now, in regards to all subdividing, Crescent Ave had a fire, which I worked with the fire department. They subdivided the house into 2 brand-new homes that are, to this day, still vacant. Now, you want to put 114 new buildings in here and congest the, part of my work, I'm going to try and use a better word, crap, out of this town. Hey, I'm doing the best I can.
You're doing great.
Like, is there anything that you guys have to add to that? I know you're not gonna talk, because you have to go in your secret squirrel meeting behind the doors, but, what's going on?
Well, we have a ordinance in place, we have laws in place, and we have to find a way to work within what's in front of us. There's no secret squirrel meetings. We're going to vote in front of you tonight. That's just the way it is. We have to work within the parameters of what we have in front of us, Dan. I mean, it's that simple. We can't tell if in a perfect world, I mean, we all loved the plan that was in place with the 54 single-family homes. That is no longer his desire to put that plan forward. If his desire is to put a different plan forward, then we have to give that the same consideration as any other plan, unless I'm going to approve it in its entirety. I'm just saying, by law, we are bound to listen to the gentleman's plan, listen to the professionals, and give weight to everything that you say, give weight to everything the professionals say, and give weight to the law. I mean, that we're bound by. It's not.
I understand.
And it's not opinion. This isn't about opinions up here. We all have opinions, but, we can't vote on our opinions.
Do what's right for the town, not for each individual, please. Thank you for your comment.
You're welcome. Is there anyone else that wishes to speak on this matter?
I'm back here, but I forgot to mention there's a pair of golden eagles that are nesting back there. They've been back there for about 7 years. Peregrine falcon, Cooper's hawks. Now, I see all of these every day because they fly over my yard, and I've been back in that woods and watched them many days. That concerns me because there's some squirrel that's back there shooting deer and letting the bodies lay there. Now, I've had the police back there because of that. And that's not a good thing. And I would hate to have people in these new places opening their doors and shooting our way, because I might have to shoot their way. And that would be a rotten thing, wouldn't it?
Well, I agree with your love for wildlife, and I think that would probably fall into the purview of someone in that department, wildlife gaming.
Fish and game.
Yeah, that would be their purview, not ours.
Okay.
Is there anyone else wishing to speak? point in time? Are there any, okay.
I'm Dennis Steele, 1610 Davis. I don't believe that traffic report at all, and I feel that,
That's picking up Mrs.
well, I believe it's inaccurate, and
Guys,
maybe we should have another report done, if that's possible.
Well, we can't require the applicant to do a second report, but obviously the citizens, if they wanted to get together and do their own report, they can do that.
Because they rated it as B, and then already it's less than B.
I think they rated one as C coming out on Hartford, and the other one's A.
Yes.
Is that correct? Yeah.
But it's not close to what it is.
Well, from an engineering standpoint, John, do you have any opinion as to the numbers on the traffic report are skewed?
I mean, the report was prepared, the study was done in August, it was updated in November.
Mhm.
We did not go out and do our own traffic count, so, we rely on the report that was submitted by a traffic engineer who's licensed in the state of New Jersey.
And typically, these reports are accurate, inaccurate?
Yes, I mean, they measure, they count the number of vehicles.
Who must have been sleeping that day?
Intersections and total flow, sorry. Sorry.
Who must have been sleeping in the car? Thank you.
You're welcome. Anyone else?
Move the public portion be closed.
Second? Motion made by Mr. Dickinson, seconded by Mr. Kachowski. The public portion of the meeting be closed. I guess Mr. Aaron would like to speak again.
Madam Chair, I'd like to address some of the comments that have been made by the public. I thought they had some good questions, and I think they're entitled to have some answers. The first gentleman that spoke from the school board, sir, I apologize, I didn't write down your name. Could you give me your name?
Mr. Buckeye.
Charles Buckeye.
Thank you, sir. Can you show me on this plan where you live, sir?
I live on Sunnybrook Road, right up with Davis.
I understand. Would you mind showing me where that is?
Where's Davis?
Oh, yeah. Left side. We have the top left side, Tom.
You're up at the top.
Behind the water tank.
Yeah, that's right, that's evergreen right there. You next one.
Thank you. I appreciate it. I want to address the questions that this gentleman raised. First of all, he said 2.5 vehicles per residence.
That's what you said.
He doesn't believe that that's going to actually happen. As the board is aware, you are governed by RSIS standards. And for the public's information, towns are no longer able to determine what parking requirements are needed for residential units. They are entitled to do that for commercial. For residential, the state 15 years ago enacted legislation that compels you to observe the counts that they give you. In fact, it's in the land use law. It was amended to include it. You must accept the RSIs. You may think it's not right. You may think it doesn't make any sense, but it's the law in New Jersey. And a lot of the comments that the folks made, which I will indicate, did ask you to do something that's unlawful. I understand that. I mean, believe me, after 40 years of doing this and doing applicants' work, objectors' work, which I do primarily today, and board work for 25 years in 14 different boards, including immediately around this area. We still represent Stratford. I understand. But when you became board members, you took an oath. And I'm sure you remember the oath. And the oath said that I will uphold the laws of the state of New Jersey and the ordinance of the borough of Runnemede. That trumps everything. The interest of the public, of course, should be given consideration. But if they ask you to violate the law to satisfy what they would like to see, you can't do that. I say that respectfully, believe me. I never want to get there. But that's your oath. You took it. You have to honor it.
I'm done.
In regard to,
That means a criminal.
first time I've been called that. In regard to the school impact, if I might, may I recall Ms. Guviello?
Sure.
I really think we should address that. Tiffany, would you come up, please? Don't worry, it's not a criminal conspiracy just because you're here. Could you please discuss with us what the data and the criteria established in New Jersey show as to the number of students that would be generated into the school district, please?
Yes, and this is probably one of the hardest things I have to do, not because it's hard to calculate, but it's hard for people to comprehend and believe. But there are standards. There have been studies done, and the most recent study that is used throughout the state of New Jersey was done in 2006 by Rutgers University with the Center for Urban Planning Public Policy, and they did a report called Who Lives in New Jersey Housing? And that report analyzed different housing types based on the number of bedrooms and how many people live in those homes versus the number, and included within that the estimated number of school-age children. This is what you would use to estimate how many children would come from this type of development. So the report says for a townhouse community or a single-family attached community with 3-bedroom units, I'm going with the 3 bedrooms because we wrote 4 bedrooms, we acknowledge 4 bedrooms is not really practical. You may have 2 bedrooms, which would be less than 3 bedrooms, but I want to be conservative. 3-bedroom units would generate an estimated 0.438 students per household. That's 50 students. Now, 50 students for the 114 units. In order to clarify what that means and to give you some perspective, I also looked at the census data. 2010 census data says that the borough of Runnemede has 1,586 persons between the ages of 5 and 19. Granted, it's dated 3 years, but between the ages of 5 and 19, 1,586 students. And 19 may not even be students, so again, conservative. Of 3,454 housing units, that's all housing units recorded in the census for the borough, that is an estimated or an average of 0.46 students per household. So the data shows that not only is it estimated of 0.438 students or 50 students from this development appropriate, it's consistent with the number of students per household in the borough. Now, I'm going to add for everyone, I have 3 kids. I have more than 0.5 students per household. However, I can guarantee you that there are people in this room who live in the borough, do not have any students in their home, either because they haven't had kids yet or because their kids are in college or moved out. And that's where the average comes from. Now, I included parochial schools in this number. This includes public and private schools, because there is a number that excludes private schools, and I did not exclude them. Again, I wanted to be as conservative as possible. So the average, some people will have 3, some people will have none. So it depends on the setup. I also wanted to provide another perspective, because we talked about how the applicant had come in with 54 single-family units. 54 single-family units. If you're building 4 to 5 bedroom units, which generally for a single-family home, you're going to have a 3 or 4 bedroom unit. 4 bedrooms. That same report for a single-family detached unit estimates 1.077 students per unit. That's 58 students for 54 single-family dwelling units versus 50 students for 114 townhouse dwelling units. And that's because townhouse units generally do not have as many families as a single-family unit. It's a starter home or it's an empty nester home. That's not to say there are no families. There are families that live in townhouse developments, but there's not as many in every single unit. What happens is you tend to grow out of the unit and move into a home when you start having families.
So
Section 8
they'll bring sleeping bags to Section 8. Folks, we tried to be respectful when you testified. I'd ask you for the same courtesy. Thank you.
And that's why it's the hardest part, because I expect all of those comments, the Section 8 and what have you, and there are different levels for different income levels, and I took the most conservative numbers in order to afford you that. Okay, so that we have
something that is consistent with the borough, using the number of bedrooms that were appropriate to and including non-public school children, so that you have the higher number included in that. It gets difficult to comprehend, but
The
it's.
bottom line is, the plan that was approved of 54 residential units would have generated more school children than this townhouse plan of 114.
Assuming a single-family unit of 4 bedrooms.
That is what was approved.
Yes, sir.
I asked Mr. Butler, he told me it was 4 bedrooms. So there's no question, and in all due respect to the public, that's the end of the impact question. You have less children this way. And what Tiffany said is right, I was going to make a comment myself. Some folks have no children. Some folks are empty nesters, the children have moved out. Those situations are situations where there's no impact on the school district, but they still pay taxes. They still pay taxes. So the lady that was concerned, who I think now is on the school board again, about the disparate payment of taxes to support this, well, right now people are paying in this borough to support schools and they don't use the schools. But that's the system. I mean, I'm not saying it's a good system, perfect system, but that is a system. Thank you, Tiffany, I appreciate that. Two other comments that were made by, again, the gentleman from the school board. Build us a new school. Well, not surprisingly, the state of New Jersey has looked at that in case law, and that's what's called an illegal exaction. It means you can't use a developer to build you resources that are supposed to come out of your tax dollars. You cannot do it. There have been 4 pieces of legislation in the state of New Jersey, and I'm sure the gentleman knows this, that were introduced to compel developers to pay a certain pro rata share on the school impact. Every one of those was knocked down or had an opinion from the state attorney general that that's unconstitutional. So, listen, I was in Eastham for 20 years. We got school sites from developers. It was rocking and rolling back then. Everybody wanted to build, and so they would give up sites. We're not there anymore. And developers don't give up sites. So I'm not telling you, I don't know that it's happened. I can tell you I haven't seen it for 15 years, since the late 80s when the market crashed. And then finally, the gentleman said maybe we should change our ordinance. Do it. Do it. I mean, you're the governing body's agent. You do the master plan. If you think that's appropriate, do it. It won't impact us. We now have what's called the time of application rule. Many of you know. It used to be the time of decision rule. That means if I came in and before you voted within the time frame required by law, you determined that you didn't like this, you could change your ordinance. But you can't do that anymore, folks, because again, the state of New Jersey has amended the municipal land use law to say that whatever the zoning was when I filed is the zoning I have to have.
The zoning says no.
The zoning says yes.
It says no sustainable impact.
Townhouses are permitted use.
It's an impact.
Not with how much you put in there.
Now, we went through the hours that were considered for the traffic. That's consistent with good practice. That's what's done in every application by every traffic consultant that I've ever heard. And I appreciate what they're saying. They like us to sit out there for a couple of weeks, 24 hours a day and camp. But what Ms. Jones said is the Institute of Traffic Engineers have found that there are peak hours for uses residential. That's when the most traffic comes. I appreciate one gentleman who said, my kids come home at 3. That's because it's not the highest time for traffic. So if you have a school bus that comes through, it's not when everybody else is going to work or coming home from work. That's the key. Property values. One of the witnesses said, consider that. You can. And I know the chair knows that. Again, it would be illegal for you to consider the impact of any project on the valuation of other homes. And you have no testimony. You have a gentleman who is well-intentioned, and I'm sure he believes it, that says, my house isn't going to be worth as much. Is there a real estate appraiser here? Is there an expert? Is there anybody to counter the testimony that you've heard? There isn't any. There isn't any. There was one question. I don't know the answer to this, by the way, so this is sort of a loaded question, because I told you I never ask a question when I don't know the answer, but I thought it was one of the ladies that asked this. Deanna, what is the impact of this project on Sheffield Court?
Sheffield Court.
Yes, it was you, I apologize.
I want to refer my traffic. From an impact, yes, we are having our access opposite Sheffield Court. However, that is in the most appropriate location according to both RSIS as well as industry standards. You're supposed to locate an access opposite an existing street. From a level of service standpoint, it's going to be sufficient capacity, I believe, and I'm referring to my traffic report, so please bear with me.
Which traffic report? Is it going to be asked?
I'm referring to the August 21st. However, the results are still the same even if you use the November values. There's going to be a level service being better for an unsignalized intersection. Again, that is a great level of service. Again, it means waiting less than about an average of 15 seconds. Again, it's an average. Some people wait 5 seconds, some people wait 20 seconds. It's sufficient for a residential type area roadway.
And Deanna, correct me if I'm wrong, Evesham is a county road.
Yes.
Would you explain to the folks that are here what that means in regard to this board's ability to do anything as to Evesham?
The intersection of Evesham Road and Harper Drive is controlled by the county. So if there's going to be any improvements, again, that's going to be subject to the county when we have to go for our application to them.
We normally say as lawyers, and do you agree that the county has jurisdiction over a county road?
They do, yes.
Okay, thank you, Deanna. Just a couple more, because I think the questions that were asked are, they're entitled to have answers. Some folks were concerned about the disturbance. I checked this with my engineer. I'll ask him to confirm this. We are removing a very, 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 very small amount of vegetation, and it's not where the deer are. Well, I shouldn't say that. I don't know that. I apologize. The only disturbance is a slight area in the rear. Is that correct?
To the wetland, that's correct.
Okay. Other than that, no disturbance.
The wetlands are in the back, right?
Well, there's the wetlands, and there's the buffer.
Sorry, let me ask you this. Other than where we are constructing homes, we are doing very little disturbance.
What about the stream?
What about where the homes are going to be built?
In regard to the stream,
Disturbing 80
Is
acres?
it the exception?
we
of
said,
the
with
homes?
the exception where the homes are. The stream, if it qualifies as a wetlands, has requirements both for that stream and a buffer area, as you heard the applicant engineer. We can't disturb that. That has to remain undisturbed.
Well, New Jersey Water owns that strip that goes right down
Some of the,
on this side.
some of the wetlands comes on our property.
Some is on your property.
Yes, it is. And we would have to buffer that as well. We wouldn't be able to put anything
But there's
in
been
there.
a lot of that filled in by Sanos. Tremendous amount.
You know,
That's a
you know-
dirty word.
You know the old story. I'm not Joe Samos.
Lucky for you.
Yeah, it is like, I wouldn't make it out of here
Guys have a very bad
tonight.
disposition when it comes to him.
A couple other things. The wild game and deer, I lived in a heavy forested area. I have a lot of herds of deer on my property, and I love watching them. I understand what you mean. We will do an environmental study. What the environmental study will show you is that two things happen. Deer adapt, or they change their habitat. So they'll stay there, and they will live with the residents, or they will find another location where they can survive. They're not dumb.
Where's that?
Finally, as to the eagles, this is not a foraging area. Nesting of eagles, I'm testifying, I just want to say this, I'm not being a witness, I'm giving you an observation from having handled 5 applications with eagle nesting sites. What the United States and the DEP protect are eagle nesting sites. Eagles foraging sites, which is where they nest, are water, big water, not streams, rivers, bays.
These brown eagles are right out in the middle of Evesham Road because I've stopped my car.
No disrespect. I said what I said because you said they were bald eagles.
They're
Bald-
brown.
Okay, they're not protected.
She said brown. It's only a ball-headed eagle
That's
that's
correct.
protected?
They're protected. Brown, what you're calling brown eagles are not
They're
protected.
golden eagles.
Golden Eagles are not, Golden Eagles. Well, again, we'll do an environmental, but in all the applications I've ever handled, it is only the bald eagle that's a protected species.
I can't believe that.
But we understand, and we will look at it. I appreciate you bringing it to our attention. It's not something that we will ignore. We'll look for nesting sites. All right, all eagles, for the most part, are water foragers. Now, let me just indicate, I hope it helps. I don't know if it'll help. Maybe nothing would help, because I heard one person say, it's green, I love it, I don't know why it has to change. I understand that, but it is, and we have a right to it. We proposed 114 units. The chair asked me, what about 5 units? 5 units per acre comes out to 91.5. I rounded it to 92. You knew I would. I wouldn't say
I rounded it to
91.
90,
I know.
just so you know.
I know. I knew you knew I would. I go to the next one. But we use, it doesn't make a difference in the analysis I'm going to give you, really, very much. So that's 22 units, less than what we proposed.
Right.
So what does that mean? 19.29%. It's almost a 1/5, a 20% reduction from what we had proposed. Now, if you don't do that, and listen, I think what Mr. Rowan told you is right. I respect your position and what you do in this municipality. You make the final decision, not me. If you decide that's not reasonable, and if there is litigation, and if I prevail, you'll have 114 units. I just want you to understand that 114 is what we're requesting, and if this record supports 114, a court can't say 92. A court will say it's what you asked for. That's the way it would work. So when the public says, I don't think these guys did anything for us, if that's the way it goes down, the school kids just went down. Tiffany's numbers were all based on 114. The school kids go down. The traffic goes down. Everything goes down. No one addressed that. And I appreciate it. They don't do this for a living. I do it 3 nights this week. So I understand, what's really happening and what you argue. And I respect their comments. I respect their concerns. And I thank them for coming out. The lady who pointed out the eagles, believe it or not, that's a help to us. Because if there is eagle foraging, we need to know that. We have to do something about that. So, and the schools, I understand. As I said, 4 times, the legislature has tried to put an impact, it's called impact fee, on developers. And the courts and the legislature and the Attorney General said, you can't do it. It's unconstitutional. All of us have the same problem in every community. As Tiffany said, I don't have any children. And I'm sorry that I say I don't have any children, but I don't. But I still pay my taxes. I still support folks who want their kids to go to school. And it's the system. In any event, I first want to thank my professionals, because my professionals did a great job. You may not agree with it, and I respect your decisions, and the public may not agree with it, but I see a lot of professionals on a lot of sides, on a lot of boards. They did a really great job, believe me. The second thing I'd like to do is thank you, because your attendance, your interest in this is beyond what most boards get. Nobody violated the nod-off rule. You know what the nod-off rule is? It's when I see a board member. Nobody did that, and I really appreciate that. I think your professionals have given you absolutely great advice, and I'd like to thank the public, because with few exceptions, that being called a criminal, I think that the public has acted very responsibly and very respectfully, and we appreciate it. The last thing I will say is you heard it at the beginning, I want to reemphasize. If you decide to vote for a density variance, that requires 5 affirmative votes. Not 4, but 5 of the 7 members. I just like you to know that in terms of your voting. And I thank you for the attention you've given us. I really appreciate it.
Mr. Barron, I didn't hear where you said you were willing to curtail to the 90.5.
We want to do a market analysis to see what it does to us. But I want to be as fair to everybody in this room as I can. If you vote 92, I will recommend strenuously to my client that he accepts 92.
Well, I'd like to know that tonight before I vote.
Well, can you give me 10 minutes then?
Absolutely.
I need a little time to go over what we'll
Absolutely,
talk
sir.
about. All right, great, thank you.
Now, we'll round it off to 90.
23. Nothing, 0. Always go high.
One's doing one cigarette, the other one's going to the bathroom. Yeah, he doesn't take cigarettes.
Application, 117. Rolling, 114. Introduce What? And if he wins, who saved it? The judges got back on our hands.
But we can get his name. Yes. Judge did a lot of
The shame is on Tom, we put in question. We put him in the question. I know. What you say, what you look at something, so if you
That street, that's the first street we're all the way out.
They walked away with $1,000 in their pocket. But they walked away in the black.
So, I mean, it already takes 20 minutes. Well, I do. Everything fast. 20 minutes, I would like to play every day. And putting 14 units there. And 59 What's that?
Thank you, public, for putting up with us for another 5 minutes here. I appreciate it. This is important to us, so I appreciate you giving us a little bit more time to discuss everything, and I appreciate Jeff going out and speaking to his client.
This is what I ask the board most respectfully to do. We would like to take the period to your next meeting to look at the impact of reducing this to 90 to 92 units. I'm going to say 90. We want to revise the plan. We want to show you and the public what 92 units would look like on this site so that you can see it there and you can see it side by side to see what the reduction is. We want to calculate the additional open space that would be created because one of the individuals said, why can't we have more open space? We think it's better, and I say this respectfully, I know you might think I'm bailing, I'm not. It's very hard to advise a client when you don't know what it's going to look like. We never considered for 1 minute the 92 number. But when you give it to us, it seems reasonable. And we both agree, by the way. We both agree it's a reasonable number. We want to see what the layout looks like. We will submit the plan more than 10 days before your next meeting so the public can have adequate time to see it, even though you might interpret the land use law to say we don't have to. We will. We want them to be able to see it. And the first thing we will address when we come back, if you see the plan, is yes or no. Without laying it out, you see how much work has gone into this, how much time we spent, to say in one night, yeah, it'll work. It's not fair to anybody. It's not fair to the public because they don't know what it'll look like. It's not fair to you because you don't know what it'll look like. You don't know how much open space will be created. And we're not really sure what that layout is. I will simply say, in my responsibility as an attorney to boards and the courts, not misrepresenting, we are inclined to be fine with it. But we want to see what it looks like, and we want to show you what it looks like. So if you would be, now, let me make a comment. Go ahead.
I was just going to say, you only have a week and a half because the meeting this month is a week late.
And I'm not going to be here next month. We have people that are going to be absent next month.
Due to the
I think
holidays
we're
coming.
going to have a quorum problem in December.
Okay.
I know,
Could we be heard in January?
yes, sir.
All right, well then that's fine. I mean, I want to be accommodating everybody, and it's important to have a quorum.
And that gives us more time to review your new plan.
Absolutely. May I ask this question? I apologize for intruding. Would everyone who's here tonight, do you expect you would be available in January?
Yes.
Okay, because I don't, you know what I don't want to see is somebody that was here, if you're not here, then they got to go read a transcript. So that's fine. Well, now, let me tell you why I think we're operating in great good faith. Your period of time to hear and decide on this application is November 26th. So you have just a few days. Now, you could deny it. That'd be fun. I could claim a default approval. I just did that 2 weeks ago for the first time in 4 years to a board because they made us wait over half a year. And who knows? I think we're fine. I wouldn't do that. The way you have all operated with us, I'm very impressed. You're not only knowledgeable, but you want to be fair. And I appreciate that. I hope the public does too. So we will waive the entitlement to an approval within the statutory period. We will extend the date for action by the board until, let's say, January 30th or 31st, whatever the end of January is, just in case you don't have enough for a meeting, then we have time to do something.
Well, we would put you on the January meeting.
Correct.
Yeah.
But so we will extend. We have no problem extending to that time.
And waive your right to automatic approval.
Absolutely. We waive that, and I'll put that in a letter if you feel more comfortable to the board that we waive any entitlement. The only thing I would ask you to do, if that's acceptable to the board, is to announce to the public tonight, having heard the one gentleman's concern that's out by the water tower.
Don't need to renotice.
That's right. That there is no requirement under New Jersey law for us to renotice or republish. The folks that are here tonight know what happened. And the second thing I would ask is this. I would like the board to close the proceedings on this application with the exception of presenting the revised plan. If there are questions, we'll reopen. No problem. The public's entitled to comment. But if we just walk in and show you the plan, I would like not to have to open the public session again. But that's discretionary. You may say, no, we don't want to do it, and I respect that. It's a request. It's not a demand, it's a request. If you feel it would be better not to do that, and we'll come back in January, and if the public has questions about the plan, we'll answer them. That's
All due respect, this is probably the largest application that's had been heard and will be heard in the history of Runnemede for the past 40 years or so. So I give a lot of kudos to what the public has to say. So I know it's 11:15. We're all tired, but these guys are important to me. We're up
Madam
here.
Chair, it's not the first time a woman said no to it. I'm okay with it.
So I just want to let you know. Okay, let this be proof of notice that this will be heard without re-notification. So this serves as your notification that this will be continued until Wednesday, January 8th at 7 p.m. Okay, there will not be any re-notifications by mail. And it will be heard then, and then hopefully we will come back here and have a more favorable plan.
We will have the plan on file by, could you give us the date again, Madam Chair?
January 8th, sir.
We will have the plan on file at least 3 weeks before that date so that the public, I know Christmas is in there, at least 3 weeks before so the public can see it.
All right, thank you, everyone. Appreciate it.
Everybody needs a break.
Is there any old business to go over? Any communications? Merry Christmas. Good luck there. Motion to adjourn. Mr. Ockley and Mr. Pachowski. Thank you, everyone.